this opportunity to be heard. May it please the court, my name is Christopher Thompson. I represent the appellant defendant Susan Calhoun in this action. Although I raised 10 issues for the court, I will concentrate my argument on a few, which are the best arguments for reversal of the lower court's decision of summary judgment, and why this case needs to go back to the lower court to be determined by the trier of the facts. My argument is focused on plaintiff respondent's failure to prove it gave contractually required notice of default, strict compliance with RPAPL 1304 and 1306, the need for plaintiff respondent to have set forth its prima facie case regardless of my client's opposition, and the lack of proof of authority of Bayview Loan Services, LLC, to act on behalf of plaintiff respondent. Many of these arguments overlap and relate specifically to the affidavits filed in this case by plaintiff respondent. First is a sworn affidavit of Tina M. Tao, the pre-foreclosure coordinator of Bayview, sworn to on April 20th, 2017.
Can I ask a question? This is Justice Gish. Was the mortgage property the Ms. O'Callaghan's primary residence?
It was at the time that the loan was taken out, Judge. And if we go to, I believe it is page 1457 of the record, Mrs. O'Callaghan swears under oath that when she purchased this property, it was her principal residence. That's at paragraph 3 on page 1457. I'll also note, Your Honor, that plaintiff respondent's position has never been to argue that this was a commercial loan or an investment loan.
It doesn't have to be a commercial for it to be for it to not be her primary residence. Could be a principal residence and not a primary residence. And does the 1304 notice require, is it required for a primary residence?
It's required for a home loan, Your Honor, and that's what applies here under 1304. That's that particular
whether it's a first home or a second home or a third home or a fifth home, 1304 applies.
I believe the case law is clear on that, Judge.
Meaning, yes, that's your position.
Yes, that's my position, Your Honor.
Okay. And
so, with respect to the 3 affidavits that were submitted by plaintiff respondent in this case, you have, as I mentioned, the Tao affidavit, the Navarro affidavit, and the Smith affidavit. What's interesting about each of these affidavits is, first, that none of these affidavits provide either a power of attorney or a servicing agreement or any controlling document to demonstrate that Bayview Loan Servicing, LLC, has the authority to represent the plaintiff in the case. That by itself should be grounds for reversal of the lower court's decision. That power of attorney authorization document was never provided in this case. In addition, the Tao affidavit is the only affidavit that actually attaches documents that referred to by the affiant. And again, in that case, there is no authoritative document from the plaintiff authorizing Bayview. And the affidavit fails with respect to the 1304 notice and 1306 notice. It doesn't have any specificity with respect to the litany of case law related to that. I'd also refer Your Honor to Your Honors to the Navarro affidavit because the issue of standing came up, and I would expect plaintiff's counsel will argue, well, it was attached to the complaint. But in this case, there was a prior complaint, and in those pleadings, the note was available in those prior pleadings. So this plaintiff could have gotten it from the prior docket. But what's interesting is that you have 2 conflicting affidavits.
So you're saying we should assume that if they say that they have physical possession of it and they attach it, that it's a fraud?
No, Judge, if I may.
I'm going to let you address that on rebuttal. Think about it.
Okay.
Let's hear from
my only point, Judge.
Adversary. Your time is up, sir. Your time is up. More than
Thank you, Ron.
actually. I gave you extra time. All right.
Thank you.
Reagan?
Good afternoon, Your Honors, and may it please the court. My name is Ashley Reagan for the plaintiff respondent in this matter. With respect to the provisions of RPAPL 1304, it's respondent's position that this loan does not qualify as a home loan pursuant to that statute because it was not the principal residence of Susan O'Callaghan, the defendant. She was served in Florida. She admits in her affidavit that she was.
Does it matter? Does the 1304 notice, is it required based upon whether at the time the mortgage was taken, it was a principal residence? Is that what we look at? Or do we look at the time that the petitioner or plaintiff is looking to start a foreclosure proceeding? What's the period of time that we're looking at?
With respect to 1304, the verbiage is that it defines a home loan as a property which is or will be the primary residence of the borrower of the loan. So we would look at origination. However, the defendant swears that she lived at the property or that it was her principal residence at the time of origination, but there's no proof of that at all. And that's further belied by the fact that— So just like I asked your adversary, we're to assume that even though she said it, it's just a lie. She has to provide corroboration. If the defendant is alleging that it's a home loan, it would be our position that she would have to provide proof that at the time of origination that it was intended to be her principal residence.
Okay. I understand that's your position. I'm not exactly sure why, but okay.
Additionally, with respect to standing in this matter, while counsel alleges that because a prior action was commenced, plaintiff may or may not have taken the note from that summons and complaint, that argument is not based in any matter of fact or law. The law is clear that a copy of the note, which is endorsed in blank, attached to the complaint when it's filed, confers standing. And while the appellant's brief—
Well, no, not a copy. No, I disagree with that. What the law is that the plaintiff has to say they have physical possession. They can attach a copy to show, and along with the claim. You have to have both. You have to have the not the copy. You have to have the actual note. Right?
That's correct. That's right. Correct as well, Your Honor.
The fact that a copy is attached along with the allegation is usually sufficient under Aurora, under the Court of Appeals decision, right?
Correct. And
you don't have to provide anything more, right?
Correct. And in addition to that, our affidavit did, the affidavit of possession sworn to by Kelly Smith attested that plaintiff was in physical possession of the note as of May 3rd, 2010, 5 years prior to commencement. So plaintiff's position that we did establish standing in this matter. You would also argue that the affidavits that were submitted, the affidavit in support, the affidavit of mailing, and the affidavit of possession were admissible as business records pursuant to CPLR 4518, and that the lower court properly determined that there was no tribal issue of fact.
Okay. All right. Colleagues, any further questions for Ms. Reagan? Mr. Thompson, your rebuttal?
Yes, thank you, Your Honors. First, the idea that Susan O'Callaghan lived in Florida or somewhere else clearly is a question of fact. Her statement is she lived there at the time of the loan, and no one has said otherwise. It's a question of fact and should have been left to the trier of the fact, not determined on a motion for summary judgment. The second question as to standing, Judge, I think there's more here than meets the eye. There are two conflicting affidavits from the plaintiff. One affidavit from the plaintiff says that the note was in the possession of a servicer. The other affidavit says that the note was in the possession of the plaintiff. I think we should have an opportunity to be able to explore.
But they were at different periods of time, no?
On the first affidavit,
the problem is, if you'll allow me, is that these notes are bearer. They're bearer. They usually, at the time when these mortgages were given, many of them were just endorsed in blank, and they were and the mortgages were given to MERS. So what happened is that the note itself passed from person to person to person, or from institution to institution, and the notes were bearers. So as long as you had it in your possession as a petitioner at the time you started the action, Aurora says you have standing. It's no more complicated than that. Isn't that the law, Mr. Thompson?
it is absolutely the law, but in this case, you have two conflicting affidavits, and I'll rely on my brief on that point, Judge. The only other thing I'd like to say is that in this entire case, there is no default notice. There's one referred to in the affidavits from 2013, but no default notice under paragraph 22 of the mortgage has ever been presented in this case, Your Honor. And that's the issue. Thank you.
Thank you. Thank you. Thank you both. Okay, the next case for argument is Pace against Harwitz.
Good afternoon, Your Honor. Martin Kreslik for the appellants.
You may proceed.
Thank you, Your Honor. May it please the court. There's no doubt that Mort Hock's continuous representation of Ms. Gabor, the former executor of the Pace estate, ended at some point after 2015. And the statute—
Well, sir, excuse me. That's really the heart of the issue here. We know that the claim departure took place in 2007 with the sale of the Pace company, the patents and all that, and it was undervalued, et cetera. But we do know that in 2012, the law firm was substituted out, and it's unequivocal. And if you recall on the record, there was a great deal of discussion as to how you were able to establish the particularized, continuous representation of the defendant law firm with respect to the sale of the assets. That was the critical issue below. And what we got out of all this, and if I'm mistaken, please correct me, was about 2.5 hours worth of billable time with respect to administrative matters post 2015. So it's against that backdrop, I'm trying to understand how you believe the defendant continued to represent the original executor or the estate after 2012 is to render any of this timely.
There are two possible event dates that Morris Hock argues constituted the termination. One, as Your Honor just said, was March 2012, and that's when the law firm Farrell Fritz replaced Mort Hock with respect to a contested litigation. That's probably the most extreme of Mort Hock's positions. The record makes clear that Mort Hock stayed on concurrently with Farrell Fritz as counsel. They were billing as much as ever before in late 2012. They billed 40 hours per month in late 2012 and in early 2013. So if there was an event of severance, it certainly was not the replacement of Mort Hock with Farrell Fritz on the litigation. Farrell Fritz was hired as litigation counsel for that discrete purpose. Mort Hock stayed on to handle estate administration. That was the nature of its representation. That's what it was hired for, not just conceptually, but contractually. If you look at the retainer agreement, it says that they were hired for estate administration, including specifically valuation of the estate assets. The malpractice happened to be with respect to failing to value the assets correctly. However, estate administration and the sale of the assets were part and parcel of the same representation. So the answer to your question, Your Honor, is most certainly they continued to represent the client post 2012. There's no question about that. And we concede that there's a paucity of hours once you get into 2014 and 2015. The hours become more scarce and they progressively become more infrequent. And at some point at that time, the relationship was severed. We don't deny that. However, pinning the precise date of that event is critical in this case because it makes a difference as to whether this case was timely or not. Now, they claim their secondary position, Your Honor, is that the event was February 2nd, 2015, right, when Ms. Gabor, the executor, entered into a stipulation where she extracted herself from the executor position and allowed her successor to bring malpractice claims against the firm. Now, that February 2nd date is insignificant. It's an as-of date of, at that time, a draft stipulation. Nobody had signed the stipulation at that time. The first party to sign it was February 11th of 2015. And why is that important? On February 10th, 2018, 3 years later, the parties entered into a tolling agreement. So the statute of limitations is tolled from between February 11th, 2018 through December of 2018. This action was filed in November of 2018. So if the severance occurred anytime after February 10th, 2015, this action is timely, and we say that discovery is required to figure out exactly when the severance took place, because there's nothing in this record that is conclusive as a matter of law that constitutes severance. And I think the—
Can I ask a question? This is Judge Gish.
Yes,
so
Judge.
the February 2nd, 2015, as of agreement, meant that the executrix could no longer act as of that date, regardless of when that stipulation was signed or not. Is that correct?
No, that's not correct, Your Honor.
So did the executrix continue to act as an executrix between February 2nd and February 11th, 2015?
Your Honor,
did she do anything in her capacity? And could she have, honestly, under the agreement between the parties?
Your Honor, I think she could, and she did.
How
was not officially.
How could she?
Well,
really, how could she? I know it wasn't signed till the 11th, but you put in or not you, your clients, and the executrix put in the as of date. She would have been ultra vires. She had no authority, zero authority. Anything she did between that time was without authority, including directing counsel to do anything on behalf of her as a fiduciary of the estate. I just don't understand, with respect, your argument that just because it wasn't signed, that the as of date is meaningless.
It's the as of date of a settlement agreement certainly has meaning and import. For example, rights and obligations flow from that date. But in this case, we're talking about her state of mind and whether her trust in the law firm was severed on that date. And
well,
you cannot
we're also talking about her authority to direct the law firm to do anything. She can't have continuous representation as a fiduciary hiring an attorney when she had no authority to hire the attorney.
But
trust or no trust, she couldn't do it. Her authority had lapsed.
But the attorney billed her, and she did use the attorney's services. There was actual representation, as is reflected in the record. It may have been scarce, but it's there. And Your Honor,
I'm gonna let you further address this on rebuttal. Let's hear from your adversary, since your time is way over.
Thank you very much, Your Honors. This is Marion Rice from Labatt Balkan, representing the defendant respondents in this matter. Justice Shulman hit the nail on the head when he reflected that the malpractice that is alleged against Mort Hock in this matter arose out of allegedly negligent sale in 2007. And in the absence of the continuous representation doctrine, the statute of limitation would have expired here in 2010. But Mort Hock did continue to represent the executor after the sale, and there were some tie-up issues, including preparing the accounting based upon the sale, presenting the accounting to the court, and then the plaintiffs filed objections. Mort Hock originally appeared in the objections, and then on March 15th of 2012, Farrell Fritz was substituted, and Farrell Fritz was Ms. Gabor's attorney in connection with any issues that arose out of the sale of the 2007 business. So right there, you've got a rupture there. Now, in his reply brief, counsel does cite a number of, it's on page 6 and 7 of his reply brief, Counsel refers to page 286 and 287 of the record in order to demonstrate that there are multiple charges that have to do with the surrogate court litigation. But that's not accurate. If you look at the actual pages in the record at 286 and 287, you will see that in the summary that appears in the respondent's brief, my name is edited out because those 2 pages of the invoice reflected services I was rendering to Mr. Klazowski because at that point in time, he had been subpoenaed as a non-party witness. He was not representing Ms. Gabor, and at each and every one of those entries that are reflected in the respondent's reply, the appellant's reply brief, there is clearly indicated on page 286 and 287 of the record that there was no charge to Ms. Gabor. So yes, while Mr. Klazowski did record his time preparing for his deposition that I represented him at back in 2012, when the plaintiff conducted his deposition over 2 days, it was not something that was billed to Ms. Gabor, and it was not in furtherance of representation to Ms. Gabor. Farrell Fritz represented Ms. Gabor at those depositions. It was not services rendered to her, and certainly does not constitute continuous representation. The few other ones that are pointed out in the reply brief have nothing whatsoever to do with the matter. The entries themselves show that it doesn't have anything to do with the business, shows that they have to do with other investment partnerships that the estate had as part of its assets, and had nothing whatsoever to do with the 2007 sale of the businesses. So turning then to the assignment, the as-of date is so significant here. So let me just give you an example. The tolling agreement in 2018 that plaintiff's counsel referenced in his argument was dated as of February 10th. I didn't sign it until February 14th. Does that mean that it wasn't effective on February 10th? No. The parties to that agreement said when it was effective, and it's effective on February 10th. The same thing happened in this case. On February 2nd of 2015, Ms. Gabor, in order to get another $100,000 in executive commissions and to extricate herself, allowed her adversaries to sue her attorneys. Mordhock had no knowledge of this. Mordhock was not representing her in this. This was something that was done completely in order to gain a personal advantage at a point in time when conceitedly, plaintiff concedes, there was a paucity of any administrative entries. And I do go through them in chapter and verse in my reply, in my opposing brief on pages, I believe it is 16, going through each and every entry and how either was not charged, it was purely administrative by a paralegal. There was no continuous representation that would support the doctrine, which is case law, and which is made, by the way, for the benefit of the client, because the client has the right to repose trust and confidence in their attorney. There was no trust and confidence in Mordhock when Ms. Gabor agreed with her attorney, Farrell Fritz, to allow the plaintiffs here to sue my client. It just doesn't exist. And yes, counsel's right. There is no case on all fours that says the assignment of malpractice claims against your attorney terminates the attorney-client relationship. And that's for 2 reasons. One, as I say in point 3, no other state allows this, and I don't believe that New York, if it did a proper analysis under the general obligations law, would allow assignment of legal malpractice cases, but I will rest on my brief for that point. The second point is, who would make that argument? Who would say I'm allowing my adversary to sue my client, to sue my attorney, but yeah, I really like the guy and I'm reposing my trust and confidence in him. It's not what occurred in this case. The relationship was severed at 2012. What's important here is what happened 3 years before February 10th of 2018. And as the record shows, as a matter of law, and as the court had said in the case I believe that Justice Kern had in the trial court level, and this court affirmed, I lost my mind, but it's in the brief, where we talk about how just correspondence among attorneys or with the client that's purely ministerial has absolutely no basis to control a continuous representation talk. If the court has any questions, I would be happy to answer them.
Any questions, colleagues? Mr. Kresiak, 2 minutes, please.
The entries that I put into my brief are just exemplars. There are many entries in the record where there were, in fact, charges and show that Mordhock was involved in the litigation attending to document production and also depositions. I would urge the court to look at the record. With respect to the subject matter of the representation, it's too narrow a reading by Ms. Rice to say that the continuous representation did not pertain to the sale of the companies. There are entries in there pertaining to sales of assets. Ms. Rice just said so, assets of the estate. That is the same thing. It's a different asset, but the representation must be read broadly. It was a representation with respect to the administration of the estate, including specifically valuation of any assets of that estate. So the continued representation was one and the same. There was no difference.
Okay. I think we understand your points. Thank you.
Thank you, Your Honor.
Thank you both, counsel. All right, the next case is Fleet National versus Impo.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor. The argument to respondent.
All right, you have to do something about your volume.
I'll speak up, Your Honor. Thank you.
That'll do it. Thank you.
And Brian Maloney for the appellant, Savoino Copper and Brass Mills, who's the successor in interest to the original depositor of the funds in this.
Well, are they the successor in interest? Isn't that one of the issues? So let's deal with that
It is
first.
one of the issues. Let's
Yeah.
dig into it. And, there were three primary errors that we set out in our opening brief. One's a legal question, and I think the other two are factual. And so I'd like to address that legal question first, and that's the time bar under CPLR 211B. Now, the motion court didn't properly grapple with CPLR 211B. The date of the default judgment in this case was in June of 1997. And the first appearance in this action by the respondent was in August of 2018, 21 years later. And so in those circumstances,
response to your client seeking to get the money, the unclaimed funds, right? It was the first time they showed up and they said, nope, not them, us.
that's correct. That's the first time they appeared in the case.
But
And,
of course, they say, counsel, that you acknowledged the debt during the course of the privatization agreement where you did pay them some money. So there was an acknowledgement that you say that expunged the debt, but they don't agree with that. So that acknowledgement comes from whenever the privatization agreement was, it 2005?
2003, Your Honor. That document is, I think, fairly clear that it extinguishes the judgment. So if you were to get into the facts,
Well, does it extinguish the judgment, or it just says that you, as you, don't have to pay the judgment, but that the company with whom you're claiming to be the successor still may have liability under that judgment? It didn't extinguish the depositor's liability, and that's who the judgment was against.
And I think that that's the key point on the legal question, Your Honor, on why 211B applies, because there's no action taken against the original depositor, SOC, for more than 20 years by what is now the bankrupt estate of the...
Well, they didn't, at some point they stopped existing. And I guess one of the problems that I have with your position, and maybe you can reconcile it for me, is how you could claim the right to take as the successor in interest to SOC and also not have the liability that SOC may have under the 2003 agreement, which in fact acknowledges the 1997 judgment. I mean, how can you wear different hats for this? Either you're the successor or you're not the successor.
We are the successor. We're happy to take on the question of whether there are liabilities, but that issue hasn't been litigated. I mean, the posture of this case shows that there are really disputed questions of fact. So if we were to put aside 211B,
but we have to deal with it not just as to whether the 3 million euros paid off the judgment or not, but the issue of whether the 20 years has otherwise been the we know we call it a statute of limitations, but I think it was correctly characterized in the briefs as really a conclusive presumption that can be rebutted, that we have to deal with the issue of whether the 2003 agreement effectively rebutted the 20-year presumption such that the bank can still collect on the judgment against SOB through which you are seeking to get these funds.
Yes. Well, 211B, yes, Your Honor. I mean, 211B states that the presumption is conclusive except as against a person who within the 20 years acknowledges an indebtedness or makes a payment of all or part of the amount recovered by the judgment, or is heir, a personal representative, or a person whom he otherwise represents. So if the position is that that Beogradska Banka is now asserting a claim against Savoyno Copper and Brass Mills in this action, then 211B then they would have 20 years from the date of that payment. But I don't think that was the position below. And I don't think that's the position set forth in the papers. Mr. Marion, in the agreement, it says that they won't take any actions to seek recourse against our client in the privatization agreement. So they are not making a claim here today against Savoyno Copper and Brass Mills. They are saying we have a judgment from 1997, and we are here in 2018 seeking to enforce it against the original depositor, Savoyno Overseas Corp.
Yeah,
now
they also say,
right. Karen, yeah. I'm a little confused because you're saying that you did, assuming you're the successor, you acknowledged the debt in 2003 based on the privatization. So why wouldn't that recommence the statute of limitations then? And they're not now going against you or SOC, they're going against the interpleaded funds. But why then was the 2003 agreement an acknowledgement of the debt which would recommence the 20-year statute of limitations?
I'm sorry, Your Honor, the question is why is the 2003 agreement not an acknowledgement of the debt?
Yes.
The 2003 agreement would fully settle the claims against SCBM. I don't think it's an acknowledgement by the original depositor.
Go ahead. I'm sorry.
I hope I answered your question.
But didn't the original depositor, under the terms of the 2003 documents, wasn't there a right retained against the original depositor to proceed beyond the monies that were paid, the €3 million, for the value of the judgment? Wasn't it retained? Maybe not against your client, but certainly the original depositor.
If that was the case, then they should have filed an action within 20 years under CPLR 211B. And if
no, I'm not. We're not. But why doesn't the 203 agreement, as an acknowledgement of the debt, extend that though? It's an acknowledgement of the debt. So, I mean, either you're the successor or you're not. Why do you get to wear two hats? Why do you get to wear a hat here to take all the money, and then your hat that you wore when you signed the 2003 agreements was only in your individual capacity, and you didn't retain the liabilities of the entity, the depositor, that you're now claiming you're the successor to? It seems so inconsistent to me.
Well, our position would be that there are disputed issues of fact in that event that have not been litigated, because the first time that this respondent appeared was 21 years after the default judgment, and there was not consideration of the record or sufficient consideration of the record by the trial court. You have an affidavit where the person who signed the affidavit appears to be different from the name of the person on page 1. You have a claim that there were 2 other credit lines for the other party in the action, Impo Saval, the aluminum mill, based on a letter from 1993, where it only references 2 credit lines rather than 4. And so these are facts that we have to litigate if the statute of limitations doesn't apply.
Right, then we have that issue. Okay. All right, you'll have some time in rebuttal. Let's hear from Mr. Marion.
Thank you, Your Honors. Of course, I'll answer any questions you have, but it's very simple. We have a judgment.
It's definitely not simple, sir.
Yes, Your Honor.
It's not a simple case.
We had a judgment regarding 4 credit lines. They paid 3. Your Honor, Judge Gish, you're 100% right. Article 4 of the agreement that Counsel Maloney is talking about says specifically that this is only as against his client, who's copper. It's not the original depositor. It reserves all claims to go against aluminum, to go against SOC, which was the original depositor. So
did the original depositor in any way participate or sign that 2003 agreement?
No, Your Honor.
So if they didn't, don't you have a problem with the 20-year conclusive presumption?
We don't have that problem for a few different issues, a few different reasons. The first issue, of course, we would say that here they are, Copper claiming that they are the successor, and in that document they named the judgment as what they are partially satisfying. So I would say that that is an acknowledgement, but let's also say that their right to bring the time bar was waived. They did not mention it in their answer regarding 3211, of course. If you don't,
how could they raise it in the answer? You didn't show up to assert the claim until they went into the interpleader action and made a motion and said, give us the money. And then you show up, other than the lien. Let's leave the lien aside for a minute.
Your Honor, I'm glad you asked that. There's an excellent answer to that. We did not just show up in 2018. We were named as a party to the action in 2003, only 5 years after the judgment. Counsel is saying we should have brought a duplicative action only for ourselves against the money, but we were in that. Yes, it was stayed in 2004. He did not bring a motion to default us. He left us in the case. We were.
When did you? But you didn't show up in the case asserting your claim until when? When was the first time you showed up in this case?
First time I showed up was 2018, Your Honor, but the judgment is asserted at paragraph 14 of the complaint as we having a right to the money in fleet, and the Copper, which is of course the appellant, did not deny that paragraph. That paragraph is admitted. So they
Justice Lebedev also stayed the case for the precise reason that Diagnostic was in bankruptcy. In 2004, she entered that order. So putting, I guess, the other parties on notice in the interpleader that there was this claim. That's your argument.
That is correct, Your Honor. That is also a very important factor in this. And I do have permission of the Serbian Bankruptcy Court to be in this case and assert our claims here. Okay, that said, Your Honor, yes, they waived the argument because, as I just brought up, it was not something I brought just in my motion. It was in the complaint, and they admitted it at that time by not denying paragraph 14 of the complaint. So they had their opportunity to raise this under 3211. They chose not to. They chose not to deny it. It then waived their opportunity to even bring this call. That said, what the judge was faced with was a judgment with no satisfaction of judgment, and a person who's merely a shareholder claiming to be a successor in interest with no further basis than the fact that they're a shareholder. Those don't add up. They're not a successor in interest. Shareholders are not all a successor in interest to a corporation. That's the basis, the only basis of their claim.
They don't claim to have taken over all of the assets and liabilities.
Correct,
right?
John.
It's not what we normally think about as a successor in interest.
They did not take over their business. They did not take over their location. They did not take over the secretaries or the phone numbers. They did not take over the contracts. They merely became later on a shareholder, they claim, of 66%.
Right, and not 100%. Right.
And not 100%. As a matter of fact, I'll note that at pages 103 and 104 of the record is aluminum acknowledging that there were still 2 credit lines that they take responsibility for. So that is after the division of the original corporation, the creation of copper and aluminum after the original company was severed. Now, I'll note that SOC remained its own company until it was dissolved in 2012. So there's no allegation.
Nine years after the 2003 agreement by which the appellant became acquired an interest in it.
That's correct, Your Honor.
All right. Okay. Any further questions for Mr. Marion, folks? All right, Mr. Maloney, you have 2 minutes.
Thank you, Your Honor. Yes, you know, Savoino Copper and Brass Mills, my client, is the controlling owner of the original depositor. They have a 2/3 interest in the funds by agreement. That's in the record, with a 1/3 interest.
Did they assume all of the obligations and the assets? Did they take over everything?
So that's not in the record. I think that the successor liability cases are not apposite here. You know, we do control you know, the rights to these funds as the 2/3 owner, but I don't think that we take on 100% of the obligations in the same way as in those products.
We don't have any kind of indication other than what you say, Impo said about their 33 1/3% interest, do we? You say we have a deal with them, we'll work it out, but there's nothing in writing. There's nothing from them acknowledging that you're acting on their behalf in this. Is there any document?
There are writings in the record with an agreement between those two parties as to how the funds should be distributed upon receipt.
These funds, the funds on deposit, or you're talking about in general the interests in SOC?
It is I believe, attached to the Bozovich affidavit. I'm sorry, I don't have that right at hand.
That's all right, I'll look for it. You're saying there's a writing.
And I think that the point about these other credit lines and this claim against Impo is that, you know, if those were there, why aren't they in the reconciliation of all of the activities through Savoino Overseas Corp in the 2003 privatization agreement? There's no reference to 4 credit lines. There's a reference to 2 credit lines. And I don't think that the evidence is competent on that point to support any claim under the default judgment that hasn't already been settled by the 2003 agreement. And so that's a question of fact that if 211B were not enforced, would have to be litigated.
I mean, I understand your argument. All right, anything further, colleagues? Thank you, counselors.
Thank you, Your Honor.
Thank you very much. Okay, the next case up is People versus James Corey.
May it please the court, Matthew Bova for appellant James Corey. I'd like to start with the sufficiency and weight of the evidence point and then move on to the burden shifting error and summation. The prosecution failed to establish guilt beyond a reasonable doubt as a matter of law because the prosecution failed to prove unlicensed entry beyond a reasonable doubt. In this case, there was an apartment with 3 tenants.
Can I ask a question? Your argument hinges a lot on the fact that one of the 3 occupants of the apartment did not testify. Under the authorities, such as People versus Quinones, isn't it true that in order to prove that there was no license or privilege to enter, you don't need every occupant of the apartment to testify? Isn't that true?
It's only true, Your Honor, if the circumstantial evidence proves unlicensed entry and proves lack of invitation. The unique fact in this case is that there is no circumstantial evidence disproving invitation. There was absolutely no evidence.
2 of the 3 women who lived there said, well, we don't know this guy. We didn't ask him in. We didn't ask him to go through our stuff in the apartment. So I'm having trouble understanding your argument.
Because the prosecution did not call Hannah Bibb, who was another person that could have authorized entry into that apartment. Without her testimony, the prosecution cannot prove the
So
total.
again, why is that not why is that distinguishable from the Quinones case, which said you don't need every occupant of the apartment to testify that they didn't let him in?
Because the Quinones case expressly says if, and the key word is if, circumstantial evidence disproves invitation. And I think the briefing in this case confirms that there was no circumstantial evidence disproving an invitation from Bibb. The prosecution has tried to cobble together a speculative theory based on a number of factors that simply amount to nothing but speculation and guesswork. For example, they claim here that we can infer that because there was blood, a blood spot, a tiny blood spot on the bed sheet, that must have come from some kind of effort to unpick the lock. But there's no blood on the door. This is just pure speculation. The prosecution additionally claims that, well, we know that Bibb did not invite Mr. Corey into the apartment because after this incident where property was stolen from another roommate, they were still friends. And if property was stolen from one of the roommates because of someone Bibb invited, that friendship would have ended. I mean, this kind of friendship speculation theory, besides being inconsistent with common sense, I mean, I don't think every friendship ends because someone else does something to someone's property. But in any event, it's pure speculation. Again, the video, the same point. If we look at the video, the prosecution tries to guess that an indiscernible object in the video, and the video time is at 14:51, and it's specifically from 30 to 39 seconds. But if you look at that, you look at the object that they claim is a tool that may possibly have been some kind of tool for picking a lock or somehow getting into the apartment, that's again pure speculation. The object actually looks like a comb at some points. So this is pure guesswork. The unique thing about this case, unlike Monique M., and unlike Quinones, and unlike the Thornton case from the third department.
Excuse me, I'm Judge Schulman. What's your reaction to the statement from your client in prison where he was seeking to pay somebody off to not prosecute the case? What's your reaction to that, where someone's an invited guest?
Again, Laura, that would just be speculation because that would be a consciousness of guilt theory, but there's no evidence that justifies the theory that was consciousness of guilt of burglary as opposed to pure larceny. You know, as this defense was presented to the jury, the defense presented to the jury was, yes, he probably committed larceny, but that's insufficient to find burglary. So all that call does is demonstrate that he's trying to perhaps interfere with the prosecution and perhaps having consciousness of guilt as to larceny. But it does not in any way indicate consciousness of guilt as to burglary. And that's the critical element that was in dispute in this case.
Mr. Bova, with the few minutes that you have left, could you address the sentencing issue?
Yes, Your Honor. The sentencing scheme here elevated Mr. Corey's sentence by decades on the grounds that it was a violent felony burglary. That statute is unconstitutional because of the unreasonable and irrational distinctions that are in that statute. Under that scheme, if a person commits trespass into a dwelling, even if it's unoccupied, with the mere intent to commit a crime, the minimum sentence upon 3 offenses is 16 years to life. Reckless manslaughter, however, negligent homicide, aggravated DWI, residential arson. Those offenses under this scheme.
I understand the effects. So now, but the question here is, that was a legislative choice to otherwise categorize this crime as a violent felony. And if the standard is that it would otherwise have to be irrational, why is it irrational? What makes it irrational? And what is wrong? What is the flaw in the reasoning by the third department and People versus Johnson, which confronted this issue?
Your Honor, Johnson did not confront this issue. Johnson was not about the unconstitutional distinctions in the statute. Johnson was about the freestanding question of whether there's a rational basis to subject recidivist burglary to a 16 to life minimum sentence. But that's not our claim. Our claim is based on the distinctions. What we're arguing is that because the legislature has created these unreasonable distinctions, that's the constitutional violation. Because it makes absolutely no sense, and it is purely illogical, to say to someone who has destroyed human life through grossly reckless conduct that they can receive a sentence as low as 3 to 6 years in prison for numerous reckless manslaughter acts. But if you commit 3 trespasses of a dwelling with intent to do nothing but steal, the minimum sentence is 16 years to life. No reasonable person would conclude that the reckless destruction of human life is more offensive to society and more culpable and more worthy, less offensive to society and less culpable than the mere trespass with intent to commit any crime. That decision was unreasonable. So yes, the legislature did make that decision, but the legislature did so unreasonably. And it drew a distinction that elevates what essentially amounts to a property crime as being more important than the reckless destruction.
Mr. Bova, I mean, I happen to think you have a strong argument about that distinction. However, I don't think it's irrational, because the legislature could find that trespasses often lead to the occupants defending themselves, which often leads to violence or death. So I can't say, how can you say it is completely irrational? You and I might have made a different distinction, but I can't see the irrationality argument.
It's irrational, Your Honor, because finding that the mere possibility of violence, the mere possibility of physical harm is more culpable than the actual causation of death and violence makes no sense. That's why it is an unreasonable and irrational determination. And I think, as the Angelos case that we cited in our brief explains, victims too expect that there will be sensible sentencing distinctions. And when a victim, for example, looks at this sentencing regime and says, well, this person, such as Mr. Corey, got 16 years to life because he trespassed into a dwelling with intent to commit a theft, as is the prosecution's theory here. But someone who destroys human life, the judge has the power to sentence that person to as low as 3 to 6. Someone who burns a building, which also can cause serious injury, can get sentenced as low as 3 to 6. And someone who repeatedly commits driving while intoxicated, which is far more risky, far more capable of destroying life than a residential burglary. Anyone looking at that distinction would conclude that it is irrational.
Thank you, Mr. Bova. We're going to hear from your adversary, Ms. Chanda.
Yes, good afternoon, Your Honors.
Could you address the sentencing issue first?
Sure. May I please report? Melancha Chanda for the people. So this is a settled issue. As Your Honor pointed out, Johnson is on point. In Johnson, the defendant argued that the sentencing scheme that categorized second-degree burglary as a violent felony was, I'm sorry?
I just say it's settled in the third department. I mean, sometimes we disagree. So
sure, I can go to the.
So we've never addressed it, although we might be inclined to go along with the reasoning of the third department. So explain to me the reasoning.
Okay, sure. So the reasoning is, first of all, the legislature has the authority to designate crimes and as it sees fit, and there just has to be a rational basis. And in this case, it's settled at least that the rational basis for designating second-degree burglary was because of the likelihood, probability of intentional violence in the process of a home burglary. And that, as far as back as Keppel, again, maybe that's second or third department, but that has been upheld as rational. So the rational basis standard is a very low, lenient standard. But I do want to address the rationality that defendant mentions in this case. He completely ignores the fact that there is a discretionary persistent felony offender statute, that in the instances that he cites in which there are multiple arsons or multiple negligent homicides leading to multiple deaths, he doesn't explain why a court in the case wouldn't impose a sentence just as high as the violent persistent felon sentence in this case. So there, the irrationality falls apart because there is a commensurate sentence available for someone who commits these crimes that defendant has identified. And again, this is a legislative decision. There's a case we cite, People v. Walker. Again, it's a federal case, Third Circuit, but it's instructive, in which in that case also the defendant had said his crime was punished more harshly for potential violence rather than crimes he identified as involving violence. And there the court again said you ignore that there were the availability of commensurate sentences, and that's the case in this case. And again, it's up to the legislature to determine whether to designate crimes that involve intentional violence more harshly or as more serious crimes than others involving reckless or negligent conduct. And that is what the legislature did in this case. Any further questions on that? And again, it's a rational basis is the appropriate standard, and it was met in this case. I will turn to reasonable doubt unless any objections. I do want to point out, as Your Honor did mention, Quinones and other settled law allows people not to have placed Hannah Bibb on the stand to prove unlawful entry. I believe defendant ignores the wealth of circumstantial evidence and focuses on two things that I'd address later, but without going too deep into it and belaboring it, as Your Honor mentioned, 2 of the 3 roommates were very close friends from childhood, mostly. They did not give defendant permission. Gotti herself, one of the roommates, said that when she came back, she realized no one was home, and she was the last to leave the home that morning and the first to arrive. The whole apartment was ransacked, and again, considering how close these ladies were as roommates, that also led to the reasonable inference that it was burglary.
Ransacked. I thought Ms. Bibb's room was left pretty much unscathed. The roommate who did not testify, her room was left unscathed.
Sure.
So, you know, so the whole house was not ransacked. And does that give rise to any inference that is controlling here?
No, Your Honor, I believe I meant to say, and I apologize if I wasn't clear, I meant to say the ransacked condition of 2 of the 3, a large portion of the apartment in which 3 close friends lived could lead to the reasonable inference. But with respect to her room not being ransacked, I think the prosecutor in summation had a great point. The layout of the apartment very well could have led to the reasonable conclusion by the jury that defendant had gone first into Gotti's room and then into Dash's room, where he had come upon the necklace and something had caused him to bleed on her bed, and that might have precipitated his earlier departure from the apartment than expected. So that there were many reasons, or at least one plausible one, for why her room had not been approached. And I do believe, I think what defendant misapprehends is that circumstantial evidence isn't speculation. And that's what he insists on arguing, that every evidence that we've presented here of circumstantial evidence of his unlawful entry amounts to speculation. If that were the case, then Quinones would have been rendered toothless. In this case, there was, again, abundant circumstantial evidence, again, including his own words while he was in prison. And with respect to the 2 points that defendant pointed out about the lock and the surveillance video, these were really defensive points to say that a lack of forced entry didn't mean that there was no, there was license entry. And finally, I mean, I won't belabor, but I wanted to address the summation point, unless the court does not want to hear, because I believe my opponent will probably address that in rebuttal. If I may have a few moments to address.
You have a minute and a half left on your argument. So
sure. And I just want to say, besides being partially unpreserved, defense counsel here had complete leeway to argue that the people, in the absence of Bibb's testimony, did not meet their burden of showing unlawful entry. But once counsel decided to advance and posit outlandish theories that had no basis in the evidence, that the prosecutors and the people were entitled to respond to that. And that's all we did. And we repeatedly reminded the jury, as did the judge, that the burden of proof rested solely on the people, never shifted, and that we were merely responding to theories that defense counsel hypothesized, even though counsel said he didn't have to do anything. He went further and presented these theories that had no basis and were frankly a bit offensive, and the people had a right to respond to that. So unless there are other questions, thank you so much. We rest on our brief.
Mr. Bova, you have 2 minutes rebuttal.
So I just want to make it clear that the prosecution correctly under Canones is conceding, as it did in its brief, that the mere fact that 2 out of 3 people testified is not enough to prove unlicensed entry, that circumstantial evidence must otherwise prove unlicensed entry because Bibb did not testify. Quinones is a great example because in Quinones, the defendant was seen going up the fire escape. That supports the inference that even if you didn't call the hosts that could have possibly invited the defendant inside, that the defendant was not invited because invitees do not enter through a fire escape. But that's not this case. The unique thing about this case is there's no evidence of forced entry. There's no evidence of even entry through any windows. There's no fingerprints on any windows. There's nothing other than the prosecution's speculation as to why we can conclude on a barren record that Mr. Corey was not invited in by Bibb. And there's no question that the prosecution is allowed to respond to a defense's claim that the prosecution has failed to meet its burden. But the prosecution must do so by citing evidence that has been presented to the jury. It cannot completely destroy the heart and soul of the defense theory by saying, as the prosecutor did here, there is no evidence that Bibb was invited. The prosecution, under People versus Reed, and as the case was charged to the jury, has to cite circumstantial evidence affirmatively proving those elements. It cannot shift the burden to the defense by arguing that there's no evidence of an invitation. And the problem here is that as this case went to the jury could have absolutely convicted because of that impermissible theory. The impermissible theory that because no evidence proved that Mr. Corey was invited, he therefore was not invited. That's not how the burden of proof works in a criminal case. That's not how the burden of proof works in any case. And as it went to the heart of the defense here, it was reversible error. Thank you.
Thank you. Thank you both. Okay, the next case for argument is Omega Diagnostic against Attica.
Attica and Siemens. Good afternoon, Your Honors. May
Attica
it please...
and Siemens, correct.
Good afternoon, Your Honor. May it please the court. My name is Jack Glansberg with the Abulafia Law Firm on behalf of plaintiff's appellant, HPML Realty Corp. I just want to make clear that though the original notice of appeal was on behalf of both Omega Diagnostics and HPML, we are only moving with respect to HPML, the property owner. And that is because the lower court erred in applying the same statute of limitations accrual date to both of those parties. Omega Diagnostics was the contracting party with Siemens and Attica. HPML, the property owner, was not. In fact, the respondents have always conceded that HPML is not a contracting party, only Omega. The lower court determined that HPML... Should
we be looking at under the Oyster Bay case about whether the appellant was had the functional equivalency of privity with Siemens here?
Well, Your Honor, that is the ultimate argument that has been presented by the respondents. The lower court simply stated in referencing the Newberg case that property owners are held to the same accrual standard of completion. But I agree, the question is functional equivalent of privity, and I agree that Oyster Bay case is a perfect example of that. And though in the Oyster Bay case, the court found that there was functional equivalent of privity, that was based on the determination that the owner of that property was a third-party beneficiary. They were in.
Here's my question to you. That's true in that case. But in order to have the functional equivalent of privity, does it at all times have to be a third-party beneficiary, or can it be some other kind of relationship?
Your Honor, from my review of the cases, it does have to be an intended beneficiary. At a minimum, there has
It's
to be
only a third-party beneficiary. That's what's meant by a functional equivalent of privity.
the way I view the cases, yes, Your Honor. The way I have read the cases, yes. In the Newberg case, they said.
Dr. Kern, what's the significance then of Newberg, which specifically says that the accrual rule applies to property owners? How are you distinguishing that case?
I don't have to distinguish it, Your Honor, because in the Newberg case, the court said that that property owner was the intended beneficiary of the work. In that case, Your Honor, it was a school trying to sue contractors for the installation of a pipe system within a library. And it was, even though the school wasn't the contracting party, the court said the school was the intended beneficiary of that work. So even in that case, and there are a number of other cases that I cite, Your Honor, including Stapleton and Ossining and Gordon, where property owners were held not to be in the functional equivalent of privity. It is not a blanket rule that a property owner is in the functional equivalent of privity simply because they're a property owner. They have to be.
But there was more at work here. I mean, this wasn't just that they were a property owner. There was a relationship between Omega and the property owner here. They were controlled by the same principle. There were interconnected provisions of the lease and the contract regarding liability, even with their two hats on. Wasn't there more than just, this wasn't a usual landlord-tenant relationship between Omega and HPML, was it?
Well, respectfully, I believe that it was, and the burden in the motions to dismiss and motions for summary judgment was on the respondents to demonstrate that there can be functional equivalent of privity merely because an individual owns both companies. There is no case or law for that. None certainly cited by the respondents, and that would eliminate what's the very essence of corporation business law, that these entities are separate. And with respect to the contracts and agreements, the only document that involves HPML is a waiver and consent to the installation of this MRI machine. That only document specifically says that HPML will incur no benefit from this machine. It does not belong to them. It is not theirs. They cannot put a lien on it for non-payment of rent. HPML has no rights to this MRI machine. So if we're going to look at the contracts and the documents, it's going to show that HPML is not a party to these contracts. HPML
so counsel, one thing that follows from that, I just want to eliminate an issue, is that you're not, HPML is not asserting any claim pursuant to the service contract because it wasn't a party to the service contract, correct?
Correct. The only cause of action that I'm seeking to preserve is HPML's negligence cause of action against the parties. That's the only one that I'm seeking to preserve. The lower court, and perhaps it wasn't the most artfully pled pleading. I'm willing to admit that it should have been pled a little better, which is why I'm also requesting that the court conform the pleadings to the proof, which is admitted by the respondents that HPML was not in contract with any parties. And we did assert negligence and breach of contract causes of action separately. They may be pled in the alternative, and a negligence cause of action cannot exist where a party is in privity. So the lower court fixated on the fact that HPML also asserted or seemingly asserted a breach of contract claim to say they were in privity, which is not the case. The facts demonstrate that. The record demonstrates that. The only document that even relates to HPML is their waiver saying we are not a party to, we are not incurring a benefit from this MRI machine. So they were not the intended beneficiary. Clearly, Omega was. They were not involved in the construction. All of the communications and correspondence, even as described by Siemens and Attica, was on behalf and with respect to Omega. And the words are certainly not
Glansman, your time is up, so I'm going to ask you to finish up and save the rest of your argument for rebuttal.
Okay, Your Honor, I'll save the rest.
Okay. Attica, 4 minutes.
Your Honor,
Judge,
I agree
the parties.
You want Siemens to go first?
Yes, we do. We
All
discussed
right,
it between ourselves, and we're happy with that.
Go ahead.
Your Honor,
Siemens,
Rob Joyce
Mr.
for
Joyce.
yes, Rob Joyce for Siemens Medical Solutions. So, a radiology imaging provider brought an MIR machine to be installed in its leased premises. The imaging provider's principal also owned and controlled the entity that owned the building. So this is not an arm's length landlord-tenant situation. You have a single principal of both entities, and that is the good Dr. Parnes, and Dr. Parnes knows obviously intimately what Dr. Parnes did on behalf of Omega. So
But
that
we
is.
don't normally disregard corporate entities or business entities, do we?
No, and we're not asking you to, and you don't have to find the functional equivalence of privity. And
So I'm going to ask you the same question I asked your adversary. The meaning of functional equivalence of privity, does it require that there be a third-party beneficiary relationship, or can it be something else?
it absolutely does not require that it be a third-party beneficiary.
What
Newburgh,
does it require?
I think that if the parameters of functional equivalence of privity can be found in the Oyster Bay case. And I think the key there is knowledge and consent, that the owner knew about and consented to the work being done on the property. And on the record here, there can be no question that that occurred, both because Dr. Parnes is the principal of both entities and because there was a specific consent that Dr. Parnes, on behalf of HPML, signed to allow the work on the property. Your Honor, you also note that in terms of the close connection between the contracts and Dr. Parnes and his HPML hat has in this case, if you take a look at the duties that were allegedly breached by Siemens, their basis are all found in the contracts. So Dr. Parnes is taking a look at the contract that he signed with his Omega hat on with HPML, looking at that contract and trying to find duties that were allegedly undertaken by Siemens on the project and relying on those duties to present the negligence cause of action. So there is a very close connection between HPML, Dr. Parnes, and HPML with the construction at the premises. Your Honor, I think if you also take a look at the decision in the decision in beyond the Oyster Bay case, if you look at it's important to distinguish the cases that plaintiffs rely on that talk about damage to property other than that was owned by the owner. Here, obviously, HPML owned the property. So the cases where the owner bought the property and actually where the owner controlled the property, where constructive privity was found at Sears, Newburgh, and Oyster Bay, need to be distinguished from cases like Mork versus Escobar, Public Service Mutual, Atlantic Express versus Weeks and Gordon, where there was third property involved, where the owner had no the entity that was alleging damage had no control over that property. I think, Your Honor, if you also take a look at the criteria that the court in the Ossining versus Anderson court and the Stapleton courts looked at, I think Siemens showed in its brief that all that criteria has in fact been met. Knowledge of work, reliance on the contractor, conduct linking to the contract, and demonstrating understanding of the plan's reliance. The record shows that all that criteria has been satisfied in this case.
Thank you. All right, Attica.
Thank you, Your Honor. We join in everything that Siemens counsel argued as to the distinction between Siemens, between HPML and Omega. We agree with the court. You know, if if HPML had been organized as a separate corporation to own the fruit stand on the corner or to own a strip mall down the block where Dr. Parnes' significant other owned a hairdressing salon, it would be a significant difference in the relationship between the parties. But because HPML was formed and organized specifically to own the building in which Dr. Parnes' radiology practice was located, suggesting that they are completely separate corporate entities with no overarching similarities and no intertwined interests is specious and defies logic. The court addressed this once in 1937, saying that the knowledge of a director of a corporation can't just be deemed to have evaporated when that same director of a corporation sits on a separate corporation. And no court has seen fit to have to address that again, specifically because it defies logic. With respect to Attica, there isn't, unlike Siemens, there isn't a written contract that either Omega or HPML has been able to come up with to say who did or didn't execute that contract when Dr. Parnes was wearing his hat talking to my client. And any expectation that the court below would have been able to divine which hat Dr. Parnes was wearing when he described the work that needed to be done on his premises, and to expect the court below to have been able to say, well, yes, he was clearly speaking only with his tenant hat on versus both his tenant and his landlord hat, also defies logic. That's completely preposterous in the absence of any sort of written contract with Attica. With respect to statute of limitations purposes, we agree that this more than meets pardon me, I'm losing my words. It more than meets the functional equivalence of privity test, because there is that very clear express knowledge and consent to the work being done on HPML's premises. Even if you're assuming they are two completely separate and independent corporate entities and giving them full faith and credit for those distinctions, the fact of the matter is the landlord was standing there looking over the tenant's shoulder every step of the way when all of the contracts were being entered, when all the negotiations were taking place, when all of the work was being done, and all throughout every step of the operations. To say that they could deny any knowledge of everything that was being done at any particular time is equally ridiculous. Even if we were to say there wasn't functional equivalence of privity, though, and to say that this is strictly a negligence cause of action, with respect to Attica, there was only one discrete act that Attica performed, and this is a construction defect claim. The cause of action in a construction defect claim accrues, and as in any tort, when the injurious conduct took place, not when the consequential injury, when the consequential damages may have arisen at some remote time. This isn't a continuous tort. It isn't a trespass or a nuisance claim. Attica was called in to do prep work for the installation of an MRI machine. By definition, the prep work has to be concluded before the MRI machine can be installed. Attica was finished with all of its work on September 10th, 2012, and never stepped foot on that premises again after the MRI machine was installed and Siemens signed off on that work. No matter when they noticed that injury.
Finish up your argument. Yeah, you've exceeded your time, so finish it up. Finish up your
sure.
thought.
So even if they proceed strictly on the tort claim accrued when Attica completed its construction work in 2012, and even the tort claim would be barred by the statute of limitations.
Thank you.
Of course.
Mr. Glansberg, you have 2 minutes.
Thank you, Your Honor. Quickly, with respect to Attica's position that it's not clear which hat hired Attica, In Attica's own affidavit, record page 192, paragraph 3, their affidavit says, in 2012, Dr. Harold Parnas of Omega Diagnostics hired Attica. So the record clearly establishes that it was Omega that hired Attica. It was Omega that hired Siemens, not HPML.
Judge Kern, what's your specific response to the argument that under Oyster Bay, a claim for construction defect accrues upon completion of the work? And in this case, there's no dispute that the work was completed in 2012.
Well, I don't believe that was the decision in Oyster Bay. In Oyster Bay, that was an issue of the third-party beneficiary. The case that Ms. Val Wheeler was referring to, I don't believe was Oyster Bay. But to answer that question, I cite to the case of Durant v. Grange Silo Co., 12 AD 2D 694, which specifically was a construction defect case. And the court emphasized there that you can't have a claim until there's an injury. The collapse didn't occur till 2018. So how can there be a claim that accrues before there's ever an injury, which is what was established in that case. And many of the other cases that I cite to relate to damages that occur several years past the completion date. The question is whether or not my client benefited from, HPML benefited from this work, and they did not. They simply did not. And for those reasons, you cannot find the functional equivalent of privity. And the last thing I'll say is that the lower court, and I don't think anyone's disputing this, the lower court said blanketly, an owner, this applies to an owner, this accrual date applies to an owner regardless. And that's not the law. And the respondents don't make that argument. They make the argument of functional equivalent of privity, which you must demonstrate a benefit to my client. The respondents attempt to do so in their briefs, but utterly fail. And for those reasons, the lower court should be reversed on that issue. Thank you for your time, Your Honors.
Thank you all, Counselor. U.S. Bank versus Calhoun.
Good afternoon, Your Honors.
You can proceed.
Okay, thank you, Your Honor. Good afternoon. My name is Aaron Bailey. May it please the court, I represent William Calhoun as the appellant/defendant in the lower court case. This matter is a residential foreclosure, and Mr. Calhoun is the homeowner, so there's no question there. The case comes up before this court on appeal of the summary judgment granted in favor of the plaintiff successor bank. We are asking this court to reverse the lower court and either dismiss the respondent plaintiff's complaint upon a search of the record, or to reinstate the case and allow the appellant to continue with the foreclosure settlement conference regime and to complete some discovery on the matter of the RPAPL 1304 notice. We also move on the grounds that the foreclosure settlement conference was not actually terminated based on the Supreme Court's initial denial of relief for the plaintiff.
Judge Kern, did you ever move to restore the action, though, to the settlement conference calendar? Was that part of the relief that you actually sought below?
It was the relief. It wasn't necessarily spelled out in the order, but certainly was the relief in our motion, our initial cross motion in 2013. It's inherent in the relief we asked for, and I believe it's specific in our brief from that time. But the default at that conference, my client's default by failing to appear at the second session of that conference was vacated. He had relied upon a non-attorney legal service scam, for lack of a better word, and Judge Sherman.
You got the relief on that, though.
Restore it?
I'm sorry, I didn't.
After it was vacated, did he specifically move to restore the action to the settlement conference calendar?
I believe we asked for that relief in our brief, and in Judge Sherman's order from 2013, the default in appearing at that conference was in and of itself vacated. There really is no other place for it to go but the foreclosure settlement conference part, because the default was vacated, Your Honor. May I continue? The principal argument we have for dismissing the plaintiff's complaint on a review of the record by this court is that the plaintiff respondent has failed to strictly comply with the notice requirement of RPAPL 1304. And as the court is aware, that's a condition precedent to suit. And without strict compliance and without the plaintiff's burden of demonstrating strict compliance, the case has to be dismissed at the, well.
And counsel, essentially you're arguing that the Sutton and Mitcherson affidavits don't set forth personal knowledge of the predecessor and interests procedures with respect to mailing 1304 notices, right?
That's absolutely correct, Your Honor. And just to speak to that point, I can actually cite to part of the record that I think will benefit the court. On page 27 of the record, which is where the Mitcherson affidavit begins, it begins at 27, but at paragraph 10 of her affidavit, she essentially shows her cards, so to speak, that she knows nothing about the mailing procedures of the initial lender, which was Wells Fargo. She states, I hereby certify and affirm that in accordance with Rushmore Loan Management Services, LLC's standard business practices and procedures, and in compliance with RPAPL 1304, a 90-day notice was mailed to William Calhoun.
Right.
But there's no contest.
Right there.
Sorry?
Never mind. It was a passing comment.
Okay. There's no contest here over who actually sent or allegedly sent the 1304 notice. It's on Wells Fargo letterhead. There's no testimony in affidavit form or otherwise that contradicts this, and that's in the record A70. That's 77-A of the record. That's where the 1304 notice comes in. We cite to the case of Rice, which is from this court in 2017, and I think Rice provides an even more compelling case for relief in that what Rice does is it says that even the present loan servicer has to proffer the testimony of some person who works there who knows about the mailing practices and procedures at the time that the notice went out. What we have here is an even more compelling case in that Rushmore is now 7 years plus removed from the mailing of that original 1304 notice, and it wasn't by Rushmore. It was by Wells Fargo, which is a giant bank that's separate, as far as we know, from Rushmore. And no matter how many affidavits the respondents want to submit, no matter how many vice presidents can say, well, we onboarded the records from Wells Fargo, it doesn't cure the defect. And the defect is simple. The person.
I'm gonna ask you to wrap this up, Mr. Bailey. You're past your time, okay? And I think we understand your argument, honestly.
Thanks,
so let's hear from Ms. DeChico.
Good afternoon, Your Honor. Jacqueline DeChico from J. Robin Law for the respondent.
So what are you relying on to prove that you complied with RPAPL 1304? What proof do we have?
We are relying on specifically proof from records from the United States Postal Service, which are sufficient enough to establish the mailing of the notice. There is no statute.
Does it matter that the certified mailing receipt that you gave us is undated and contains blanks?
No, the certified mailing receipt does contain matching certified mailing tracking numbers. It contains a matching borrower name. It contains a matching address. And it is actually signed by a recipient, which further establishes that it's delivered, which isn't even required by statute.
It's not signed by the defendant, though, right?
The signature is illegible. It's not. It's unclear as to who signed it, and actually, there's no statute or case law that pinpoints what exactly must be provided as evidence to establish proof of mailing. Here we have a Postal Service record to establish mailing. We also have affidavits from the loan servicer to further establish.
How do you respond to your adversary's point that the people who are putting in affidavits have no personal knowledge of the procedures of their predecessors that undertook these actions years before?
Personal knowledge is not required in an affidavit. What's required is that the affiant reviewed the books and records of the of the servicer or of the plaintiff in
That's not
making
exactly
the
true.
affidavit.
They have to have some familiarity to otherwise indicate that these are business records, that they're familiar with the business practices.
They have
They
to
don't
have
have to be the
familiarity.
people who actually generated the records, but they have to have some personal knowledge of the procedures of the predecessor. Just the fact that they physically got records doesn't make them admissible under a business records foundation. That doesn't lay the foundation, does it?
CPLR 4518 does not specify that personal knowledge is in and of itself required. What's required is that a review is made of the business records and that they
But
can
how do you know they're business records if you don't have any basis to make that conclusion? You didn't generate them. You don't know the procedures of your predecessor.
Business records can include incorporated records from a prior servicer. And as long as they detail that the records were
as what? As long as what? Isn't there, it's not
that the records, I apologize.
No, I mean, this is what I'm trying to get at. That's true. You can get records from your predecessor in interest, and you can try to get them into evidence. And you don't have to be the maker of those records to get them into evidence, but you have to have some kind of basis for the conclusion that the stuff that you got are business records, that they were made in the ordinary course of somebody's business, that it was the ordinary course of the person's business to make such records, and that they were contemporaneous, right?
Both affidavits, and specifically the affidavit of mailing, does satisfy CPLR 4518 in going through those requirements that the business records were incorporated in the ordinary course of the servicer's business to incorporate a prior
servicer's business.
But even if this court were to find that the affidavits themselves were insufficient enough, an affidavit is not required in order to establish mailing. Mailing can be established in a plethora of ways, one of which would be a United States Postal Service record.
The other stuff that you're relying. So we have to really look at that if the affidavit's no good and see if the mailing information that you have is sufficient. Okay.
Right, because there are
argument. Any questions, colleagues? Okay, let's hear a rebuttal from Mr. Bailey.
Thank you, Your Honor. Just very briefly, the USPS USPS records are certainly they are forms from the USPS. They are not records that have been produced by the post office. They are the front and back of a return receipt that was allegedly sent with the certified.
Look at this and really understand that it was necessarily sent to the defendant here. It's just a postal record, right?
It's not even a postal record, Your Honor. And I don't mean to say that. I'm not being facetious. It literally is the record that was prepared by Wells Fargo, maybe in 2013. Something that I put on my postal receipt is not a post office record, is the record from the law office of Aaron Bailey that is on a form from the post office. So we're not debating whether it's a form from the post office. We're debating whether that's a record that can be relied upon in exception to the hearsay bar. And it can't be, because it's not a postal. It doesn't have a stamp. It doesn't have a seal. It bears none of the hallmarks of reliable public document. That is one of the exceptions of the hearsay rule. There's also, just to briefly touch, there's no tracking provided. There may be a tracking number that was allegedly attached to the receipt and to one of the 1304 letters, but there's no background, there's no back end tracking info, and that is produced by the USPS. The court maybe can take judicial notice of that. Anybody can log on to the post office and put in their tracking number and see where their certified mailing is. They haven't done that in this case.
Mr. Bailey, would you agree that in this context, with what you're describing is the supportive documentation, that it really requires an affidavit with someone that has personal knowledge and familiar with the business practices, in this case of Wells Fargo, in which case the affiants in this case were not?
If I'm understanding your question correctly, Your Honor, yeah, I'm saying that these people who work for the the servicing company, they can onboard anything. They can onboard the phone book. It doesn't mean the phone book is accurate.
Right, and the Rice case that you cite to is very clear as to the deficiency or the problem with the vice president of the loan servicing company really not having familiarity with the business practices of how the notices were mailed.
And in paragraph 10, she betrays her ignorance of it by saying that it was Rushmore that sent this. Nobody agrees that it was Rushmore that sent it. I mean, on its face, that's going to be a credibility issue in a normal proceeding that would warrant discovery. But that here is just for me signifies the whole issue. They don't know what the process was, and now they're 7 years after the fact and removed by at least one servicer. They're saying what they've onboarded is accurate. Onboarding is not the hallmark of accuracy or an exception to the hearsay rule.
Thank you, Mr. Bailey.
Thank you very much, Your Honor.
Thank you both.
Thank you, everybody.
Thank you.
Okay, Mid-Manhattan Physician versus Dorkin.
Good afternoon. Justin Heller on behalf of the appellant Melissa Dorkin. May it please the court. This is one of a great many cases filed throughout the state.
We're familiar.
Okay.
Because I know you have limited time. We're familiar. There was an article in the Law Journal today. We're familiar. Yeah.
Very good. And here, Supreme Court, like many other lower courts, relied on this court's decision in the Schaffer case.
Counsel, this is Judge Kern. Why shouldn't we just wait? I know it wasn't requested by the party, but why shouldn't we just wait for the Court of Appeals to decide the appeal of this issue and take our lead from them rather than deciding the case right now?
Well, I mean, there's no question that, that's certainly an option for this court. I can say that it's my understanding that the Court of Appeals is not going to hear argument in the Schock case until the fall. And there's
the briefing is going to be done by the end of March.
It is.
Are you on that case?
I am. I represent the policyholder.
Okay.
And my understanding, and whether it's 100% accurate, I can't say, but my understanding is that, and I don't understand the reason, but the court is not going to be hearing our oral argument in late spring when that case would otherwise come up for argument, and so it's going to be deferred until fall. In the meantime, there's so much ongoing litigation and uncertainty over the state of the law, or I shouldn't even say that, with the Schaffer case remaining out there. It has an obvious impact on the lower courts. So
you want us to overrule our prior authority or just wait for the Court of Appeals? I mean, why wouldn't we just follow our present authority and just let the Court of Appeals figure this out? We have it split in the departments, clear split in the departments. Don't we need the Court of Appeals to tell us in this circumstance what to do?
Well, we do if this court is not inclined to reverse its prior ruling. But my pitch to this court is that, only the court can say what its, the scope of its review was. But as a reader of the Schaffer decision, and a reader of the briefs submitted in the Schaffer decision, my presumption is, well, the briefs did not discuss the legal framework behind that establishes the policyholder's right to the money.
You weren't on that case, right?
What's that?
You weren't on that case, right? You did not present anybody in that case.
I was not on the Schaffer case. No, but I was also on the Maple Medical case that the second department recently decided.
Here's what I think, though. I have to say, even if we were inclined to overrule our prior authority, and I'm not saying we are one way or the other, but even if we did, you really think that would get rid of the confusion in these cases? I think it would make it more confusing, and we still need Court of Appeals guidance on this.
Well, if this court were to overrule its prior decision, there would be unanimity between the four departments. And
well, not
I think
really. Not really, because it doesn't make the prior decision go away. Well, I mean, and it's all, and the issue's up at the Court of Appeals. So, yeah, I understand you're saying maybe we have to wait, but I don't understand how this could get any clearer than for the Court of Appeals to make a decision. I mean that, you know, whatever we do, whatever we think about this case.
Well,
that's personal. I don't know about my colleagues.
I would just close by saying that I think there is good reason for the court to reverse its decision. And again, whether the court decides to wait or not is another question. But again, the briefs that the parties submitted in the Shafford decision did not discuss the legal framework that establishes the policyholder's right to the money.
Counsel, this is Judge Kern. You're 100% right. I was on that panel. None of the analysis that is in the decision from the other department were brought to our attention in that case. There's no question about that. And we did not put our analysis in the context of those cases in that analysis. So you're 100% correct about that. The real question is whether we should address it again or wait for the Court of Appeals. And then what should we do? But we did not address those arguments yet.
Thank you for sharing that. And all I'll rest. I really, have to leave it to this handle.
One further question, when looking at the record, and maybe I overlooked it, did your client pay income tax on this as a fringe benefit? Is that anywhere in the record?
I don't think it's in the record here, Your Honor. But the issue has come up in other cases. And because it didn't come up in this case, it's not addressed. But there are exemptions for working fringe benefits, and payment of insurance premiums is considered under IRS regulation to be a working fringe benefit. And it's not
for malpractice. I know health insurance, but malpractice insurance, yeah?
Yes, that's very clear.
All right, thank you. All right, let's hear from Mr. Rosenberg.
Thank you. May it please the court. If the court is inclined to engage in analysis of the statutory impact here, I urge it to accept the logical and persuasive analysis of Judge Ruckelsman in Wyckoff Heights Medical Center versus Monroe, which is also found in several other lower court cases. The court found that it was clear that the insurance law 7307 did not contemplate a situation where a policyholder did not pay the premium. The statute provides that the cash consideration is paid to the policyholder who timely paid the premiums. In this case and many others like it, those two statutorily required circumstances simply don't exist because in so many cases it's the employer, whether it be a hospital or a medical group, who paid the premium. Now, the holdings from the other appellate divisions.
Counsel, this is Judge Kern. Didn't the Department of Financial Services already reject that argument, though, when they approved the plan, that there's an automatic presumption that the payer of the premiums is the one entitled to these funds?
Yes, but I'm not arguing that the payer of the premium is automatically entitled to the funds. What I'm arguing is that, and the Department of Financial Services recognized that was not, quote, not determinative. My argument here is, as the court in Wyckoff found, that the statute didn't contemplate the situation at all. And there's no basis to disregard one part of 7307 that says the cash consideration goes to and is calculated based on the timely payment of premiums, and elevate the other part of the statute that says cash consideration goes to the policyholder. As this court noted in Avella versus City of New York, it's an accepted rule that all parts of a statute are intended to be given effect and that a statutory construction which renders one part meaningless should be avoided. And I believe that is the case here. And Thus, rather than trying to force the square peg of a policyholder who has paid no premiums into the square peg, into the round hole of Section 7307, which doesn't contemplate such circumstances, the court should apply principles of equity as it did in Schaffer, which ruled there would be unjust enrichment for the cash consideration to go to somebody who paid not 1 cent in premiums. And here, paying cash consideration of...
Judge Kern, just playing devil's advocate, isn't insurance law 73073 very specific when it talks about that the plan of conversion must provide for consideration to be paid to the policyholders who held the policies? Isn't that a much more specific provision than the other provision of the insurance law that you're arguing is contradictory?
It simply says that the plan shall provide that each person who had a policy in effect shall be entitled to receive an equitable share, but it also says that the equitable share is calculated based on the net premiums that the policyholder has timely paid. So you end up at the same place. If they haven't paid any timely premiums, they're not entitled to any cash consideration. It's circular and inherently contradictory and in tension with each other. In this particular case, just to put it in context, my client paid nearly $250,000 into MLMIC and to help support that mutual insurance company. And Dr. Dorkin paid not 1 cent. So contrary to some of the language in the other appellate division decisions that it would be a windfall no matter who received the cash consideration, I don't believe that that's the case at all. The practice receiving the cash consideration would be an unexpected but welcome return on its investment in a mutual company.
You paid the money because you needed to have malpractice insurance for your employees, so why wouldn't it be a windfall to you? But you didn't pay it because you were hoping to eventually get a payout. You paid it because you needed the malpractice insurance.
I'm just saying that as opposed to somebody who paid absolute zero, for them to receive $500,000 based on the premiums that my client paid would be unjust enrichment. I'd also like to just briefly address the arguments about membership interests.
You are way over your time.
I'm sorry, Your Honor.
So we're going to let you rely on your briefs.
Thank you very much.
Okay. And this in a complex matter. So let's hear from Mr. Heller. You have 1 minute.
Thank you, Your Honor. I think it's an incorrect characterization to say that the policyholder paid zero, because really the premiums are paid as part of a bargain for exchange under the employment agreement, where the policyholder agreed to provide her services and the employer agreed to pay the premiums. And the employer got the benefit of that bargain, which were services, and the policyholder and the employer can't assert an equitable claim to the Milnick consideration, which the policyholder is legally entitled to. And so I think the argument fails on that basis. And I would just add that all of the arguments that respondent makes have been thoroughly discussed and rejected by the second and third departments. And I'd urge that the court adopts the reasoning of those decisions. Thank you.
All right. Thank you. Thank you both.
Thank you.
All right. The next case is HSBC Bank against Proctor.
May it please the court, for the appellant, Ronald Hillman, Rosemary Clee from the law office of Ronald D. Weiss. Good afternoon, Your Honor.
Good afternoon.
May I begin?
You may.
Thank you. This is an appeal of an order of the Honorable Arlene P. Bluth, which was rendered on August 13th of 2019, which dismissed the action against my client, Ronald Hillman, and severed all claims against him. We're not disputing that part of the decision. We're just saying that the court did not go far enough. We're asking that her decision be affirmed and modified by the appellate court. We submit that by dismissing the action against my client, this is a foreclosure of a condominium apartment. My client is an owner and a mortgagor. He's a 1/3 owner. By dismissing the action against my client and allowing the case to proceed against 2 of the other owners, the court did not go far enough. We believe they need to dismiss the entire action. The plaintiff doesn't have the ability at this point to serve my client and bring my client into the case at all because of the statute of limitations. The plaintiff has filed a judgment of foreclosure and sale application, which is pending before the lower court. And to allow the case to proceed with the absence of my client and also one of the other defendants who's an owner, there's 4 owners of the unit, creates an unfair result. And I think it warrants that the order needs to be modified such that the entire case would be
Counselor, isn't there case law to the effect that where there is the absence of a necessary party mortgage foreclosure action, that the result is really that it leaves that party, here your client's rights, unaffected by the judgment, but it doesn't require that the court dismiss the action. Isn't that the rule of law? And if it is, why wouldn't we apply it here? So you're not affected by the judgment of foreclosure and it goes forward against the other defaulting mortgagees.
I think the problem is that you're allowing the sale of the property. So he is affected by the judgment in that sense. If you allow the judgment and sale of the property, it affects his rights. And he's a necessary party, obviously, as an owner. So I don't see how you get around that.
Well, what do you do with that rule of law, though? I mean, the property would be sold subject to his interest in the property, whatever it is.
I don't
be
see how
cloud
you
on
can,
title.
That's the whole problem. I think it mandates that the action has to be dismissed in its entirety because there's a statute of limitations issue that bars any action as against him. So it remains a permanent cloud on title. It's a problem.
Well, there's lots of titles in the state that have clouds on it. Tons of title. It's not clear. Not the greatest to do that, but.
But now you have a necessary defendant who can actually defend the action because he's no longer a party to it. It creates this dichotomy that I'm not sure how you resolve it.
Well, counsel, this is Judge Schulman. Below, if I missed something, please correct me. Did you argue in vacating the default against you because did you argue or seeking to dismiss rather for lack of personal jurisdiction or on statute of limitations grounds that you were a necessary party? And did you argue the very argument you're making now that it can only be justified by extinguishing the whole mortgage, notwithstanding that your other co-obligors are still on the hook? Did you argue that below?
We did. I believe that we did. I didn't work on the papers, but I believe that was part of our argument. I believe it was.
All right, let's hear from your adversary, Mr. Teague.
Good afternoon, Your Honors. I am Joe Teague, and I'm here representing the respondent. Judge Gish, you're exactly right in your description of the law, but before we get to that, none of the arguments raised in the appellant's brief was raised below. They're the subject of a subsequent motion that was made and hasn't been decided. The only subject of the motion below was a jurisdiction issue. Someone wanted to get out of the case, and my client was trying to get additional time to serve, and the judge below said, no, Hillman's out. There was no mention of necessary parties or indispensable parties or extinguish, and to the extent they sought the quiet title, there was no claim to quiet title. It was solely on motion, and you can't extinguish a motion, a mortgage on a motion alone. It needs to be a claim. But getting back to the idea, yes, Hillman is a necessary party. and he can't be joined because there's no personal jurisdiction. We can't start another action against him because the statute is run as to him, but the mortgage remains valid and the action can proceed as to the other borrowers. Indeed, Hillman, in their own brief, cited a case for that very proposition, that the failure to join a necessary party to a foreclosure action leaves that party's rights unaffected. So there's no prejudice to Hillman. There'll be some partition action or something later, maybe, I don't know, but for the present time.
Does he reside in the property? Do we know?
Not at the present time. I think there's a dispute over who lives there, I think, but he does not reside there, I think, at the present time.
So his interest right now is financial. It's financial. He has a financial interest.
Correct. I mean, I believe at various times he has lived there. I believe he has maintained it as his residence. At the present time, I don't believe he resides.
Yeah, I'm accepting that your adversary is letting you use his time to answer my question. But thank you, Counselor.
Yeah.
Go ahead.
It's fine.
Finish up, Mr. Teague.
Sure. Mr. Hillman's rights in the property are going to be unaffected as this case goes forward to foreclosure, and sale will be sold subject to his interests. So he suffers no prejudice. He's not a party to the case anymore. His ownership interest will survive a foreclosure action. And there's also no basis to cancel the mortgage because this action is timely commenced as against the remaining defendants, and it can be enforced as against them, even if it can't be enforced as against Mr. Hillman. The Supreme Court's ruling should be affirmed in its entirety.
Okay,
do you have any questions? Otherwise, I'll relinquish the rest of my time.
Colleagues, questions? Okay, all right, Ms. Klee, you have, actually, you don't have rebuttal. It's 3 and 3. Okay, thank you both. Thank you for your arguments.
Thank you. I appreciate your time, Your Honor.
Thank you. All right.
Thank you.
Wolsom, 316 against 316, Valry.
Good afternoon, Your Honor, and may it please the court. Kyle Cole with Herrick Feinstein on behalf of the defendants appellants Gregory Jones and GRJ LLC. Every manager and member of an LLC is entitled to the protections under New York law that limit their personal liability for actions performed on behalf of an LLC. Now, this is a breach of contract action against defendant GR46 Bleecker LLC, of which Mr. Jones is now the manager. Every allegation made against Mr. Jones and his investment entity GRJ relates solely to actions that he took in his capacity as manager of 46 Bleecker. So New York law should immunize him from personal liability for those actions. Indeed, as this court just held last week in the Sutton 58 Associates opinion and numerous other times before that, and I'm quoting here from that opinion, which was December 29th, 2020, it is perfectly legal to incorporate for the express purpose of limiting the liability of the corporate owners. That's exactly what happened here, and Justice Chan's decision accordingly should be reversed in its entirety. And contrary to respondents' contention, there is no need and no entitlement to discovery in this action on the veil-piercing allegations. First, here the contracts actually say that only 46 Bleecker can be liable for Wolsom's claims. I'm pointing specifically to page 172 of the record.
Yeah, but the contract doesn't control a claim for piercing a corporate veil. That wouldn't control. The question is whether there are sufficient allegations that would support a claim that we can look behind the corporate entity and get at individual liability because the individuals here have satisfied that standard, which is pretty rigorous.
Exactly, and I was comforted earlier with the Omega argument to hear Your Honor note that it's disfavored to disregard the corporate form. And so I guess turning to the allegations that are actually made by plaintiffs here, that's one of the reasons that there is no need for discovery. There's no allegation, for example, that Mr. Jones cooked the books or that he commingled assets or that he somehow used 46 Bleecker to commit a corporate fraud. And that's one of the elements that plaintiffs must establish to justify piercing the corporate veil, based on all the factors that this court knows well and that are on page 22 of our opening brief. But looking at what plaintiffs actually allege here, I'm looking specifically at pages 28 and 29 of the record, which is the complaint. Those are the only primary portions of the complaint that actually address what Mr. Jones is alleged to have done. They allege that he failed to provide access to the building by changing the locks after he acquired the interest in this LLC. They allege that he refused to extend the contract's deadline for this condo conversion, and they allege that Jones allegedly threatened to terminate the master lease. In the Weiss affidavit, which was submitted in opposition to the motion, they repeat those same allegations and add a bit of color by stating that Jones personally orchestrated and caused the defaults by 4-6 Bleecker. And they state that he is not entitled to hide behind the corporate shells that he's created, and that's at 570 in the record. But discovery isn't required on these allegations because even if they're true, which we dispute, but even if they're true, they're not grounds to pierce the corporate veil. All of these allegations go to conduct that Mr. Jones was taking in his capacity as a manager, and they all relate to 4-6 Bleecker's role under the master lease. And in fact, plaintiffs concede that Mr. Jones was acting on behalf of 4-6 Bleecker. I direct your attention to, in the record, page 18, it's paragraph 10 of the complaint, states that Jones was, quote, acting on behalf of new landlord, and new landlord is the 4-6 Bleecker entity, in threatening to terminate the master lease. And plaintiffs repeat the same thing in their briefing here on pages 13 and 14, that it was all conduct on behalf of 4-6 Bleecker. And Mr. Weiss made similar allegations in his affidavit regarding Jones causing these breaches. So again, even if all of this were true, it's related to his role, to 4-6 Bleecker's role rather, under the master lease. And it's bedrock law, the Skanska USA opinion from this court said it very succinctly that causing an LLC to breach a contract does not make a member or a manager, such as Mr. Jones or GRJ, personally liable for the LLC's breach. That's exactly what plaintiffs are alleging here. The law just requires more than what plaintiffs have alleged. It must be wrongful conduct, and it must be conduct that is performed in order to avoid plaintiffs' claims for damages or otherwise defraud them. So that's a very high bar and a very heavy burden.
Thank you.
Thank you, Your Honor.
We understand your arguments. Okay, let's hear from Mr. Doherty.
Thank you, Your Honor. May it please the court, John Doherty on behalf of plaintiffs, respondents, who I'm going to collectively refer to for purpose of the argument as Wolsom. When you look at the entire record, Your Honor, which is the complaint, as well as all the affidavits, and draw all the inferences on behalf of in Wolsom's favor, trial court correctly determined that Wolsom stated a prima facie case for piercing the corporate veil against Jones and GRJ. As Your Honor, I'm sorry, Your Honor?
What are you basing that claim on?
So
what allegations that would make it premature such that you should get discovery?
Sure, Your Honor. With respect to the first element, which is complete domination of the corporation, Jones repeatedly and consistently held himself out as doing business on his own individual capacity. He sent all his emails back and forth, not through an email with 4-6 Bleecker, but with GRJ, a company that's not affiliated with 4-6 Bleecker. And in all those emails, he represented that my plan, my decision. And Wolsom only dealt with Jones in every interaction, and all the emails reflect that. And Mr. Weiss alleges that Mr. Jones repeatedly indicated he had no intention to comply with the master lease, and he, not 4-6
Well, that's a
Bleecker,
different issue. That's a breach of contract. That's a breach of contract. That's not a veil-piercing allegation.
Well, Your Honor, respectfully, a breach of contract is not the sole cause of action we have alleged here. We also have common law indemnity and contribution, which is connected to the sister proceeding, which is an overcharge proceeding, which arises from Mr. Jones knowingly charging illegal rent, which exposed Wolsom to statutory liability under the rent stabilization law. Mr. Jones also, after taking over 4-6 Bleecker, let the building fall into disrepair, which again is a harm. And we know that because all the building violations were issued after he took over.
Well, this is Judge Quinn. You keep saying Mr. Jones, but all corporations have to act through individuals. That's the nature of a corporation. A corporation can't act except through an individual. So you have to show more than that to show piercing the corporate veil, that there was some wrongdoing, and that wrongdoing was used to perpetrate fraud. And all you said is that he did everything, but someone has to do things for a corporation. So how does that reach the level of alleging piercing the corporate veil?
Right. Well, Your Honor, respectfully, this court has already held in First Americas versus Motor Fund Corporation that acting on behalf of the corporation only protects you if that you're acting in good faith. Here, we're alleging that Mr. Jones acted in bad faith. He intentionally breached the master lease by not allowing us to complete the conversion, and he also conducted illegal conduct by charging illegal rent, both of which have exposed us to liability. And this court has also found that when the individual acting even on behalf of the corporation does so in bad faith, causes a breach of that corporation of the lease, then that is sufficient to uphold piercing the corporate veil claim. And what the court decided below was that pursuant to 3212F, the affidavit raised sufficient questions of fact as piercing the corporate veil claim, and also demonstrated that evidence, which, as Your Honors know, in a court piercing the corporate veil claim is fact intensive and often involves evidence that's exclusively held by the defendant corporation, especially where it's a closed corporation. So the court directed that their motion was premature because no discovery at all has been conducted whatsoever.
But counsel, discovery is not necessary in every case involving an allegation of piercing the corporate veil, correct? I mean,
that's correct, Your Honor.
But here, dismiss when the complaint does not allege the factors necessary to pierce the corporate veil, correct?
That is correct, Your Honor. I would note here it's a summary judgment motion, not a motion to dismiss, but I would also note that we have alleged sufficient facts in the record when you look at it entirely together as a complaint with the affidavits that supports a claim for piercing the veil. And I would note, Your Honor, that the Jones defendant's motion itself offers no facts, only argument. They don't say we can maintain separate accounts, we follow proper corporate formalities or corporate structures. They merely argue, which again just raises another disputed issue of fact. It doesn't resolve all the issues of fact.
Okay, thank you. Let's hear a rebuttal from your adversary.
Yeah, just to address a few points, Your Honor. With respect to this allegation that using an email for multiple entities is somehow improper, that's just unsupported by the case law. There's case law in our reply that rebuts that. And this issue actually wasn't raised below, nor was the authorized signatory issue that's raised in the opposition brief. With respect to First Bank, I mean, that case is interesting. I understand why plaintiffs cite it, but in that case, there were fraud claims that were sustained. The case involved allegations of bad faith and material misrepresentations that, of course, discovery was warranted on veil piercing. And that case also had an interesting procedural posture in that the trial court had struck the answer prior to discovery on the veil piercing issues actually having taken place, such that the First Department, as I interpret the opinion at least, said we need to send this back. The answer should not have been stricken. It's an interesting procedural posture that I think easily distinguishes it. With respect to the premature, that the trial court somehow made this finding under 3212F, I will say that the opinion below doesn't actually say that. And there's plenty of case law such as Art Capital Bermuda and others that we cite in our briefing saying that the mere hope that discovery is going to lead to a veil piercing, evidence to support a veil piercing allegation, that's insufficient. And then with respect to counsel's final point on we didn't present any evidence of our compliance with corporate formalities and the like, that simply isn't the law. The LLC law and the cases interpreting it clearly afford members and managers protections under that. It doesn't place burdens on them to be able to benefit from the protections. So with that, I'll rest on my briefs. Thank you, Your Honor.
Thank you. Thank you both.
Thank you, Your Honors.
All right, the next case is MTGLQ Investors versus Vasquez.
Good afternoon, Your Honors.
Good afternoon.
Douglas Jones on behalf of the appellant defendant, Mr. Vasquez. Your Honors, there are several significant issues in this case regarding standing. I think the most egregious issue is that there was the discovery by Mr. Vasquez of a note with a canceled endorsement. As the court noted earlier in arguments today, It is extremely normal for a bank to have a note endorsed in blank, and that note gets transferred along the way to various servicers and so forth. Here, in this case, there are three separate signatures on notes that have been produced in this litigation. Even putting the issue of fraud aside for a moment, or forgery aside for a moment, there's three notes that have three separate signatures on them. They're clearly not the same document. And then the note, which has been set forth as the quote original, is endorsed in blank and allegedly transferred at some point to this plaintiff. But the fourth version shows that endorsement was canceled. The plaintiffs here have never produced the original note to show that if the wet document was canceled or if the wet document is not canceled. Further than that, there's extreme problems with the affidavits stating when this mortgage was, the note rather, was allegedly transferred to this plaintiff. In September of 2012, they claim, and there's an assignment, November 5, 2010, they claim that the mortgage was transferred from FDIC to MERS. As this court is well aware, MERS cannot be the owner of a mortgage. And then the transfer back out of MERS to AmTrust, which allegedly supports the standing in this case, was a transfer by MERS, which in and of itself is not proper. And in addition to that, the person who alleges to be the assistant vice president of MERS actually worked for the servicing company. There's various cases that demonstrate that. And the affidavit of Mr. Lucas, virtually identical to one examined by this court recently and found to be not a proper affidavit, is virtually the same one that's used in this case to demonstrate or attempt to demonstrate that they're standing.
So one question that I have, to the extent that your client is making arguments that the mortgage itself is that the signatures are fraudulent on the mortgage themselves, so that the mortgage is not valid. Does the fact that your client paid money on the mortgage for a period of time ratify that the debt existed or exists?
It's a good question, Your Honor. He did not pay. This is, I deal with a lot of foreclosure cases, and
Sure.
this court deals,
So,
and this
so
court
we
deals,
for today.
this court deals with a lot more than I do. And I think that it's an unusual set of facts where there was a closing in February of 2015, I believe it was, when the deed was signed, and that's the only time that my client showed up for a closing. When he left the closing, he did not have any documents, and he was rather persistent trying to get copies of his documents. The note that's allegedly the original note here wasn't signed until many months after the closing. Mr. Vasquez clearly says he only showed up for one closing, but so he did make some mortgage payments, but he stopped making mortgage payments prior to being supplied with a copy of the mortgage. And as soon as he was supplied with a copy of the mortgage, he said, that's a fraud. I did not sign that mortgage. I did not meet anybody. I believe it was in May of 2002. It was notarized. He appeared for a closing in, I believe it was Westchester County. The documents were notarized in Suffolk County, I believe it was. So there's a lot of issues with the signing of the documents, and he did not make, prior to finding out, or once he found out that the mortgage was not a document that was signed, he hadn't made any payments on that. So he did not ratify the mortgage.
Thank you. Let's hear from your adversary at this time. Mr. Lebec,
Yes, it is, Your Honor. Ronald P. Lebec for the respondent. If it may please the court, with regard to appellant standing arguments, I believe that the plaintiff respondent here has adequately proved its standing by the attachment of the note to the complaint, as well as by an affidavit from plaintiff's servicer that state the note was delivered to them on September 1st, 2010. I think that clearly establishes that plaintiff had standing to proceed with this action. My main point, though, is that these arguments are not properly before the court. We moved for summary judgment, and I believe it was 2014. Defendant opposed and moved to amend their answer. Respondent was granted summary judgment, and appellant did not appeal that order. Rather, they moved to renew and re-argue, and that denial was then appealed. So I don't think the appeal of the summary judgment motion is properly before the court, to the extent that
isn't the appeal of a final order in the case an appeal of everything in the case? Once you wait till the final order and you appeal, doesn't that bring up for review everything that's happened in the case?
That was actually my next point, Judge Kern. To the extent that the summary judgment order might be considered an intermediate order, which necessarily affects the judgment, that only applies if it has not already been reviewed. So in addition to not appealing the prior order, when appellant appealed the denial of his motion to renew and re-argue, he had a full and fair opportunity to address all the issues before the court. The same issues with regard to fraud and forgery were raised in that appeal.
And well, that appeal, didn't we only address the renewal and whether it was appropriate to renew, rather than addressing the merits of the underlying summary judgment motion?
It did address that. That was the main gist of the court's decision, but the court also stated that it was rejecting the remaining of the appellate's arguments. So I think the brief on those appeals necessarily decided the issues, or the appeal necessarily decided the issues here. I mean, basically, appellant is getting a second crack at attacking the summary judgment motion, which I believe is improper pursuant to the doctrine of the law of the case. Be that as it may, with regard to the merits, I don't think appellant has anything here. Respondent has made out a prima facie case for foreclosure by presentation of the note, mortgage, and evidence of the borrower's default with the loan history. And that with regard to the judgment, the referee's findings are substantially supported by the record. I just want to hit on the ratification argument that Justice Gish brought up. The appellant paid the loan for over a year. In addition to that, in his seventh affirmative defense, he alleges that there were improprieties at the loan closing that he admits to attending in his affirmative defense. He also applied for a loan modification, which can be evidence of his confirmation of that debt. I would also note that the signatures on the HAMP modification application and the Dodd-Frank certification next there too match the appellant's signature. That's all I have. If the court has any questions, I'd be happy to answer them.
Any questions, colleagues? Thank you.
Thanks.
All right, Mr. Jones, you have some rebuttal?
Yeah, I do want to address the prior appeal. There was, in fact, on the prior appeal, there was a motion made by plaintiff to limit the appeal specifically to only the renewal aspect. So by plaintiff's own motion, and this court granted the motion, the only thing that was permitted to be brought up in that prior appeal were the renewal issues. So there was no notice of appeal filed at the time from the summary judgment motion, and it was not able to be included in that prior appeal. So the prior appeal only dealt with whether or not those affidavits were able to be reviewed by the court on the renewal motion. And just on the modification issue, I'm not, this comes up as well. I mean, the people go into the modification part, they're told to fill out forms and submit them for a modification. They listen to the mediator, which, they think is a judge. They don't really even understand where they are in the process. And so whatever documents were filled out for a modification, I don't think that those can be considered as a ratification of the mortgage.
Right. Any further questions, colleagues? Thank you both.
Thank you, Your Honors.
Okay, the next case and the final case on the calendar is American Youth against 4000 East 102nd Street. Okay, you can proceed.
Thank you, Your Honor. I think there are two questions in the case. The first question is whether the Supreme Court read the lease and the amendment to the lease correctly. And secondly, even if it did, is there an issue of fact as to whether the tenant cured its default in a reasonable time? I'm going to be arguing that the court did not read the lease correctly, and that even if it did, there are issues of fact. So I want to start with what the original lease says. And this is from page 188 of the record. This is the premises. Premises means the second floor, which the tenant is renting.
I'm sorry. I'm having some trouble hearing you, so
sorry.
Go ahead. When you started to read the lease, you cut out from me.
I can be quite loud. Let me know if I'm too loud.
I like loud.
Okay, if you like loud, you come to the right place.
Okay, good.
That it is aware that the premises and the premises in the lease are the second floor the tenant was renting are subject to a resolution of the Board of Standards and Appeals, BSA, dated August 8, 2006, granting the use of the premises as a physical culture establishment. Copy annexed. Tenant agrees that it will pay for and do the construction required pursuant to the resolution and the plans to which it refers. Doesn't stop there. Tenant shall have 1 year to obtain a certificate of occupancy as a PCE. I suggest the only reading of that makes sense and that fits with the words is that the tenant agreed to obtain a certificate of occupancy, which of course means for the whole building, because that's the only kind that was available, and that that certificate of occupancy would permit the tenant, I apologize for the phone, Your Honor, go away in a minute.
It's okay. It seems to be kind of the, what we now deal with in our virtual world. That's all right.
My spouse picked it up. The only reading that makes any sense, I think, is that they had to get the certificate of occupancy and one that would permit the use of the premises as a PCE. And that's consistent with what the words say. It's a perfectly reasonable reading of the deal.
No, counsel, I mean, to get a C of O, there were some other violations, building code violations, but doesn't the rider place an obligation on the tenant to clear those violations?
I think it does, yes, Your Honor. And whether in any event, there's no dispute that the landlord has to cooperate. If there's something that's the landlord's fault that's preventing the C of O, of course we can't hold the tenant in default. But that's not, that was not what the judge found, not what they proved. The judge found that the judge thought it was ridiculous that the tenants have to get a C of O for the whole building. I suggest it's not ridiculous. They were renting originally half the space. They later got 3/4 of the building. The half they were renting was really the only significant impediment to the C of O because it was supposed to be a PCE and it had to comply with PCE standards. And the deal that was made was you fix it up as a PCE and you get us the C of O, which means you hire the architect, you make the filings with the buildings department. We're really not fighting much about who pays the cost. But who does the work? Who has the responsibility? Who undertook the obligation? The tenant undertook the obligation. And in the amendment to the lease, it's really even clearer. Tenant acknowledges that it has not obtained the required certificate of occupancy, and it gets a deadline of a year from that to do it. I don't see how you can read that language to say the tenant doesn't have to obtain a certificate of occupancy. I can't resist reading it again. Tenant acknowledges that it has not obtained the required certificate of occupancy. And the tenant reads that to say that all the tenant had to do was to legalize its own space. The tenant, they say the tenant didn't have.
Let me ask a question. Did the tenant legalize their own space?
Eventually is the answer, yes.
All right. And does the tenant now still have, or can the tenant, under the terms of the lease now, get the C of O and be in compliance?
Well, they can. It is still possible to get the C of O, but I believe it had happened in effect as the tenant won the case. So what do they care? But I think the process is, a few steps that are needed for the C of O now are not all that difficult, and they could get it. But then I would go to my second argument, which is you had a 2013 deadline, and I understand that the deadline isn't going to be draconian, isn't going to be strictly enforced. But whose fault is it that we're in 2021 and there's no C of O? And I think that's an issue.
Didn't the BSA specifically give the tenant more time to get the C of O? Didn't it give it till October 3rd, 2021, which still has not passed yet?
I'm sorry, what?
Didn't the BSA give the tenant more time to obtain the certificate of occupancy, which time has not yet passed?
Well, I think so, Your Honor, but I don't think that affects the obligations under the contract. The fact that the contract does not say you're allowed to take as much time as the BSA will give you. The contract says you've got to get it by X date, and I forget the date, in 2013.
But in our previous decision, we found that this was a curable default.
Well, your decision on the Yellowstone does say that. That does not entitle them. A decision made in 2016 that at that point it was a curable default and they were working to cure it. First of all, it's not binding on summary judgment 4 years later, and in any event, it's not binding. Apart from the 4 years, it's not binding anyway. A decision on a Yellowstone injunction, and the Court of Appeals made that clear in the Graubard-Mullen case. A decision on a Yellowstone is a preliminary decision that freezes the status quo. It doesn't bar litigation of the merits. The idea is to give the tenant the opportunity to cure its default, and if it works diligently to do that and does it in a reasonable time, it wins. The only problems this tenant has are, one, it didn't cure the default, and two, if it had cured it last year, it would have been way too late because it's their own fault that they took so long. And maybe I should dwell on that for a moment. The record is clear on why and what accounts for the vast majority of this long delay is the tenant decided for purely economic reasons that it was going to take out a staircase that it didn't like because it was a hole in the floor that they're running a dance studio and they say we need that square footage. We can't have enough students. We can't make enough money if we don't have that staircase out of there. Nothing in the lease said they could do that. They say they got oral approval, which we vigorously dispute. But in any event, that happened, and the Department of Building says you can't do that. You need two means of egress from the cellar. And they said, no, you don't. We don't need it. And they said, yes, we do. And yes, you do. And it went on for 4 years. And finally, they won the argument. They persuaded the Department of Building. But
right. Yeah. All right. All right. Let's hear from your adversary.
Thank you, Your Honor. Lauren Walkler for the respondent. I think we really need to go back to the beginning of this lease to talk about what the demise premises are or is and what was required by the lease, which said that it was going to be used as a physical culture establishment, a PCE, and that the tenant was required to obtain what they call the certificate of occupancy for use as a PCE. The tenant was renting at that time the second floor and the second floor only. To say that she, and this is what the court below said, to say that she had agreed, or American Youth had agreed to get a certificate of occupancy for the entire building when she was renting the second floor only.
What kind of certificate of occupancy did AOIT, or I'm sorry, the American Youth Dance Theater, what did they agree? What kind of C of O did they agree to get?
They agreed to legalize the space for the.
No, but that means that you're not, you have to acknowledge the word, I'm sorry to interrupt you, but you have to acknowledge that the word certificate of occupancy is in the lease. It's in the amendment. It's there. And so what kind of C of O were you supposed to get?
We were supposed to get a certificate of occupancy for the demised premises. Now, whether it was used inartfully, everybody has used that word. In fact, everybody who has looked at this has said it's for the demised premises. Their notice to cure says for the demised premises as a PCE dance studio. She has never.
Can I ask a question though? Sure. Do you acknowledge that once the use of the premises changed, that you couldn't get a C of O, a partial C of O? You had to get a C of O for the entire building. Isn't that true?
No.
I mean, isn't that as a matter of the applicable laws regarding certificates of occupancy?
What I'm saying, Judge Gish, is that she can get a legalization of her space for a PCE for the entire building. That has to be obtained by the owner for the entire building. She never agreed, nor can you read the lease to say that she agreed to get a certificate of occupancy for the entire building. It doesn't say that anywhere in the lease.
But my point is something different, which is that you can't get, in this circumstance, you can't get a C of O just for the demised premises. There ain't no such thing, right?
And that's why she agreed to legalize her space for the use that she had, which was a PCE dance studio. And this tenant has been on the second floor since 2007, renewed the lease.
Right, yeah.
I'm sorry. Renewed the lease without the landlord saying anything about the.
Yeah, this has been going on a long time.
This has been going on forever. And the landlord has continuously, only since 2014, after they renewed the lease, which says that they couldn't renew the lease if she was in default. So had she been in default, they wouldn't have renewed the lease. And their client himself testified at his deposition 3 times that they did not mean that she was supposed to get a certificate of occupancy for the whole building. How could she? She's not even permitted to make any alterations to the building other than to the demised premises. And there were other tenants in the building. They had a vet. They had a flower store. They still have, this landlord still has a certificate of occupancy saying it can be utilized as a garage. She undertook to do precisely what she was required to do under the lease. And any other reading of the lease, as the court below said, is Judge Scheckman, that they checked her, I'm sorry, that there is no way that anyone would have agreed to do that. It's ridiculous. It doesn't even make any sense. And I do want to say one thing about the stairway, which was an illegal staircase that was put in by the landlord ages before. And he signed the permit allowing them to remove the staircase. It's all in the record. As for the diligence issue, and I hope that I've covered enough to show that there is absolutely no way that the certificate of occupancy could have been obtained if that was ever required, which it was not by this lease. And their notice to cure says the same thing. The notice of cure does not say certificate of occupancy for the building. It says certificate of occupancy for use of the demised premises as a PCE dance studio. And that is very significant because there is no way that she could have obtained or would have ever under any circumstances have agreed to obtain a certificate of occupancy for the whole building, which she didn't occupy. It's very unlike a case where someone rents the whole building.
Yeah, is there anywhere in the record that we have any idea of what's required to get a C of O for the entire building at this stage?
The landlord,
you've got the BSA approval and you've signed off on it. So that part
did everything that we were supposed to do. We did everything we were supposed to do. There is nothing else left for the tenant who could do anything. There are violations on that building that go back to 1989. Where the landlord had a boiler that was not working. He has not maintained the building. There are violations for the roof, which is his responsibility. There is no way any tenant under any lease, under any circumstances, could ever be responsible for curing violations that have nothing to do with the tenant. And that's what the case is here. In terms of the reasonableness of the The record is replete with all, and I was personally involved with all the efforts. There was zoning counsel. There was special counsel who deals with the building department, expediters trying to navigate this Byzantine archaic system of the building department, which we did, and we were able to get everything approved. And that's when summary judgment was granted. And the court was right when she said, you have done everything you're supposed to do in order to legalize your space to make the demised premises a PCE dance studio. That was the obligation. That's what we undertook.
Counsel, could the contract be interpreted to require you just to pay for the lawyer to apply for the C of O, prepared for the landlord's signature? Could that be an interpretation of the contract?
Absolutely not, Judge Moulton. And I have read this lease backwards and forwards to look for any indication that this would be something that would be an undertaken or a responsibility or obligation in any way by the tenant, and it simply does not exist. And in fact, when this was argued below, Judge Schechter asked counsel, where in the lease does it say that? And it was sort of like he was stymied there because there is nothing. And
I'm reading out the word C of O from the lease. So the words C of O are in the lease. Your interpretation doesn't require you to get any certificate of occupancy. So aren't you reading out an express and unambiguous provision of the lease requiring your tenant to obtain a certificate of occupancy?
No, Your Honor, I'm not. And the reason being is because it specifically says the demised premises everywhere, and the premises are defined as the space that she is demising, the second floor, and pursuant to the amendment, a portion of the first floor. She does not, nor has she ever occupied that entire building, and that cannot be an obligation. It says the demised premises, and their notice says.
Counsel, I'm sorry to interrupt you, but the writer doesn't modify C of O that same way, and also the agreement, the later agreement, doesn't modify the word C of O by saying, connecting it to whatever that wonderful 19th century phrase is, physical cultural establishment. It just says obtain the C of O. So you've got a bunch of different documents where C of O is mentioned, sometimes with a modifier and sometimes without. And so what are we to make of that? And the problem for you is that C of O keeps turning up in these documents.
But the initial lease, I'm sorry, Your Honor, I didn't mean to interrupt you. The initial lease, as well as the amendment, says that the space is to be used as a physical culture establishment, PCE dance studio. It refers, and that's on page 1, and actually the supplemental record has a better copy of it, and that's on 173. The amendment all refers to the original lease. This was a lease that was extended in 2012 through and including 2022, and it always refers to the same thing. It does not in any way change or modify all of a sudden. And I think very significantly is the fact that all of the parties have admitted, including the owner, and this is also in the record, that he admitted, and this is on page 132 of the record and 138 in his deposition, that he did not in any way consider the tenant's obligation to be obtaining a certificate of occupancy for the whole building.
Documents, though, I mean, it's parole evidence. It's one person's interpretation who's not a lawyer of what the documents say. So I don't know if we can give that dispositive. And also, your architect, if we're talking about people's comments made about what was agreed to, your architect said, yeah, I'm supposed to get a C of O for the premises, and then defines the premises as the whole building. So, sauce for the goose. You have another person saying something contrary to your position. The owner did say that at his EBT, which is problematic for the owner, but it's the documents that govern.
But even in the documents, Your Honor, and that is specifically the documents provide without question that they're talking about the demised premises. The legal document of their notice to cure says the demised premises for a PCE that cannot be interpreted to mean the whole building, because the whole building wasn't being occupied by this tenant, never has been, nor was it supposed to be used for a PCE except in the demised premises. So there was no other way to interpret that other than to say that she was obtaining a certificate of occupancy for the demised premises to be used as a PCE dance studio, which is exactly what she did. And that's what all the permits that she got. There is no way that she could have gotten a certificate of occupancy for the entire building because she did not have a right to alter it in any way, nor could she.
Let's hear from Mr. Smith on rebuttal. So here's my question to you. if getting the C of O requires that violations be removed from the building, is it your or alterations or work done to other parts of the building other than the demise premises, which are only the second floor, what obligation, if any, does the landlord have to undertake that work?
I would say in general, Judge, we have a duty to undertake it. If only we can do it, of course it's our duty. And I do want to say a word about those violations. They list, approximately 1 million violations. Most of them, a lot of them, are for non-compliance with the C of O. There are other violations. I don't think there's any significant violation of record now that hasn't been cured. But she makes a lot more of the violations than they should be. But I acknowledge the point that if only we can do it, we've got to do it. That's part of our duty.
So what needs to be done to get the C of O? What needs to be done?
I asked that question. I mean, I'm not sure how clear it is from the record, but I tried to figure it out this morning, so I think I can answer. They need to apply for a building permit for the work they've already done. Sorry, that's the way it works. Even if you've already done it, you got to apply. They haven't applied. They get the building permit. Then there's some other. We've quibbled about curb cuts. Curb cuts have to get fixed.
What do they have to do with the curb cuts?
Sorry?
Well, what does the second floor have to do with the curb cuts?
Actually, the one of the curb, and we're talking actually about very small matters, which we said we pay for. But the one of the curb cuts is in front of the tenant's space. And the reason that the Department of Buildings doesn't like the curb cut anymore is the DOB thinks, maybe wrongly, that the tenant changed its premises to make it no longer a garage, and therefore you don't need a curb cut, and therefore you've got to raise the curb cut to that level. I think that's their obligation, but I also nothing stands or falls on that, really. We've already said we pay for it if they'll do it. And
the reason that I'm asking this is because one way or the other, if we affirm, your client still has to get a C of O. If we don't affirm, if we say, no, the tenant has to get the C of O, it doesn't change the fact that a C of O still has to be obtained and that work has to be done. Some of it apparently due to the demise premises and some of it because of other stuff. And so I'm scratching my head a little bit. That's all I'm saying. It would seem to me that unless there's some other objective that each of the party has, that I don't understand really why this gap is not bridgeable. It's not a question.
I answer this, Your Honor. I think it would be hard to say, and I hope my client isn't listening, that both sides have been, shall we say, firm in their positions, perhaps firmer than they might have been, and that if with flexibility on both sides, maybe we wouldn't be here. However, I don't think there's anything, the court can't do anything about that. The court?
No, certainly not at this level, we can't.
The court
It's one of the things we lament about not being trial judges anymore, all of us, right? All right. Anything further, Mr. Smith?
If I could I do want to stress my favorite words in Ms. Wachtler's argument. She says what they describe in the contract is what they called a certificate of occupancy. They called it that's not, she says you've got to read certificate of occupancy not to mean certificate of occupancy, but it does mean it. And she talks about the demise premises. We've never said that she has to make the whole building, that the tenant has to make the whole building a physical cultural establishment. We think the meaning is clear. She has to get a C of O, and that C of O has to permit her to use her premises. By her, I mean Ms. Alonzo Brillante, her American youth. Her premises as a physical cultural establishment makes perfect sense. There's nothing wrong with it. It's what the lease says, and it's what it means.
Any further questions, colleagues? All right. I thank you both for your patience, and I thank you. And this session of the Appellate Division is now closed. Have a good evening, everybody.
Thank you.
Good night.